But the court is considering the purported application for that amended application as the application for amendment. Very
appear, my lord.
Tomorrow, hand over the slip, Mr. Das.
Give leave for filing this issue since I have not got the certified copy.
Devendra.
Certified copy has not yet been.
When the order was passed,
22nd of June.
when have you applied for the certified copy?
Immediately the next day.
What is the order?
The order, they have closed our evidence and fixed the hearing of a argument, fixed the suit for
All
argument.
right, fine.
My lord, may I have your-
File,
My lord, may I have your lordship?
server copy is there.
May I have your lordship? Copy is there?
Have you annexed the server copy?
Yes, yes, yes. My lord, yes.
They can in server copy.
My lord, may I have your lordship leave to mention one matter, my lord? This is item number 593 of your
What do
lordship.
you want?
My lord, I'm asking for upgradation of the matter, my lord.
Upgradations, please hand over the slip mentioning the urgency.
My lord,
I've mentioned the urgency, my lord.
Hand over the slip mentioning the urgency.
Be permitted to extension of hearing order.
Please hand over the slip, mention when it is expiring.
Yes, sir. First an order, there is a typographical mistake in the cost title.
All right.
May I hand over the order sheet indicating the correction?
my lord,
Item number 49 is the lordship's list, my lord. This is the DRT matter, my lord. The bank is
Yes.
taking possession tomorrow, my lord. It's item number 49.
Oh, it's
So-
appearing today.
Item number 49. So can we come back? I'm mentioning about notice. Can we come back at 3:15 or 4:15 as
Tomorrow you said that it with the
the
order.
bank will take possession
Bank-
tomorrow? 49, my lord.
49,
Anytime, 2 p.m., 3:15, 4:15, whatever.
all right. এটাকে তিনটে
It's upon notice, my lord.
49 টা 3 p.m. Please inform the other side.
He's there, my lord. Upon notice, my lord. I'm so grateful.
Your Honor,
my lord, item number 283. Item number 283 from your lordship list. My lord, in this matter, what has happened? Pursuant to the order passed by CGM, my lord, the bank has taken possession and they have locked my entire belongings. I wrote a letter asking for returning back of these documents.
What
My-
do you want?
My lord, upgradation. Reason,
Upgradation, please hand over the slip.
no, my lord,
Indicate that-
urgency is that my
indicate that in the slip.
I indicated, my lord, yesterday I mentioned, my lord, my junior mentioned. My lord,
Yes.
kindly fix up the
my
matter.
company has 311-1624 of
Upgradation,
expeditious disposal.
expeditious disposal. There is no urgency, madam. Yes.
My lord, kindly application for expert opinion was, my lord, allowed on a
What do you want? Upgradation. Please hand over the slip.
Today is the date, my lord. I have already mentioned it before, my lord.
All right.
Today is the date for production of documents, my lord.
Produce the documents.
My
What's
lord,
the difficulty?
My CEO will be infructuous, my lord.
You will not be infructuous.
My lord,
Your Honor,
my lord, in my matter, my lord, my study materials, my son is appearing, my lord, board's examination.
Consider, sir. Please hand over the slip. Yes.
My lord, yesterday I mentioned this matter.
may the matter be heard for the expeditious disposal.
Expeditious disposal, madam. There is no urgency. Yes.
Urgency, my lord, I'm paying that in this matter. Maybe instead, this, my lord. When my client was in the jail, my lord, in the judicial lockup of Bidhan Nagar,
What do you want?
my lord, the cancellation.
Upgradation. Please hand over the slip.
Just one, my lord. There are 2 checks which were given by way of that agreement.
Sir, please indicate that. It's difficult for me
My
to
lord, one,
remember everything.
my lord, one more indulgence, my lord. Yesterday I mentioned the matter.
All right, all of you, I will hear all of you. Yes.
No, my lord,
But the matters will not be taken up. That is why I am asking you, please indicate that.
I have indicated.
Please see, look at the mention is.
I have
Upgraded
understood, my
matters
lord.
also there is mention.
I understood, my
What
lord.
can I do?
No, my lord, but I understood, my lord.
Stop all mentions for
No, no, no.
upgradation.
I'm sorry, my lord, my lord. I'm sorry, my lord.
Please appreciate because the motions are there, upgraded matters are there. Thereafter upgradations. The previously upgraded matters, can I upgrade it over that?
No, my lord, if it is not appeared, then my lord, I will again mention, my lord.
Please, please consider.
My
this.
lord, my
Yes.
Tomorrow is the fix for argument. The matrimonial
Item number
42, then look heavy, my lord.
42, 42 টা তিনটের সময় রাখুন। Yes. What do you want, sir?
Application, but there is an urgency. I have been paying the rent as per the 17 by order. But the lease ends up on 30th July. 30th July 2026. Now, if I pay the up to June, I have paid. If I pay the rent for the July, then how that extra 1 day that will be defined. 7 by 70 order 7 to 11 D pending, your lordship. Last hard on 36/2025. Thereafter, your lordship, this is the urgency.
What do you want?
Yes.
What do you want now?
Your lordship, hearing already hearing this matter. Upgradation. And I cannot pay that in your lordship 15
Please hand over the slip. Yes, Mr. Bose.
This was heard at length by my lord Shamba Sarkar. Both parties were heard and the matter was appearing and getting upgraded. Now suddenly it can come down and very new motion. The trial courts are the mandate of the Honorable Supreme Court and an ordinate bench of this House. Finish the matter, but this was by any day as per your lordship convenience. I love the kindly fix of the any day.
Please hand over the slip.
Lordship, may I have your kind leave, Lordship? Please.
Your lordship's kindly, may I mention item number 53, that is the second method in my lord's list under the heading upgraded motion. Lordship, there we have challenged the inquiry committee set up in a post proceedings, Lordship, and the recommendations filed by it. Lordship, today, Lordship, yesterday night, Lordship, the petitioner has received information that his service will be terminated if this matter is not taken up or any
Our
order.
227 is maintainable.
My lord, there is a judgment of the Delhi High Court based on which we have relied, and Lordship, the post committee, Lordship, is governed by the civil procedure of the inquiry procedure. It is governed. Lordship, 5 minutes of time.
27 is maintainable. You have to satisfy the maintainability first, sir.
Lordship, I shall. I have come prepared with the judgment also of the Delhi High Court.
Maybe the civil procedure code applies. That does not by itself make 227 applicable.
Lordship,
Yes.
may I have your kind leave, Lordship,
Hand over the slip, yes.
Lordship, I bow down to handing over the slip for, yes, please.
It is already appearing as item number 53, second matter of the upgrade. If my
It's
lord
the
can-
second matter of the upgraded matters and others are fresh motions.
I would not have come if lordship.
That
did
is
not
what,
have-
please you decide which to be taken up first.
That is a very.
I leave it to the bar. If you say yes, upgraded, not the motions, I will take it. I do not have any difficulty.
Anytime, lordship.
Yes.
Lordship, I bow down to handing over the slip for upgradation, Lordship.
Yes,
Lordship,
please hand over.
there's only just one thing, Lordship. Lordship, this is against an order passed by the learned sole arbitrator, Lordship, where an interim final award has been passed, deciding all issues. Now, Lordship, yesterday the arbitrator has
Interim final order.
interim final award, Lordship, under section 31(6), an interim final award has been passed, deciding majorly all the issues, Lordship. Now, Lordship, I have challenged that before the learned Rajarhat Commercial Court, Lordship. However, Lordship, yesterday the learned arbitrator had filed it 2 weeks ago, Lordship. I have been slipping my handing over my mentioning slips over. Yesterday, the learned arbitrator has fixed the date for Monday for further cross-examination of the petitioner, Lordship. Now, nothing remains in the arbitration, Lordship.
Excuse me.
Item number?
222.
Yes.
This is commercial minor. If under section 12 has been granted. While minor, I am specific.
You are challenging that grant of leave.
Because minor, the claim is of.
Is what do you want now?
Minor, I'm challenging that minor. Next date is fixed on 31st July. Minor. Injunction.
Hand over the slip. Yes.
Malo, there is an
Lordship,
application
this-
for extension of interim order.
Hand over the slip. Please indicate when it is expiring.
Extension. What is the particular time covered by this Article 40 Act? Whatever injunction state the order. For that reason, I am suffering because of I have a special child in my family. Frequently, I have
Since when your ingress and egress have been obstructed?
there is a problem.
Please hand over the slip.
Lordship, the next date of sitting is on Monday, Lordship. If I participate, my 34 application will be infructuous, Lordship.
You have
Kindly-
mentioned, sir, I have asked you to hand over the slip.
Hand it
I
over,
will
Lordship.
consider because I
Kindly
have to
take-
consider the inter se urgency of all of you.
Lordship.
My lord, may I?
That's the most difficult
Lordship
part.
kindly takes it up tomorrow, Lordship. I'm led by
I can
Mr.
interrupt
Thakkar.
you also. You can go up all the slips and you can in order of serial, which is most urgent, that you can do. I can also accept that. If you take that task. Thank
My
you.
lord, may I be permitted to mention a matter for inclusion in the list, my lord? For inclusion in the list, my lord.
Motion.
Motion.
Hand over the slip. Yes.
Grateful.
Yes, call the list.
Correction of typography says
Yes, call the list.
previously determined.
Yes.
Item number 1, Millard, yesterday, Millard, I argued it MSME matter. Millard,
Yes.
Millard, I want to continue with this argument. Lord, I have taken instruction, Lord, I will to continue with this argument. My lord,
No, you want to make arguments?
yes.
Then I'm keeping it motions tomorrow. List this matter under the heading motion.
My lord, only one prayer, my lord, instead of tomorrow, can it be in the next Monday?
Next
Because
Monday, on the
tomorrow
prayer of the
preparation.
learned. Monday will be the monthly list. If you want.
Oh, my Tuesday. Yes. I'm so sorry. My lord
Tuesday.
helped us. My lord helped us.
Tuesday. Yes, next.
My lord, I am for the opposite party. Your lordship's specific query was that, my lord, I should not assist your lordship regarding the new Act 7.2, if not filed 7.3, whether, my lord, that inquiry can be done.
This is the judgment
Now, I
on
have
that.
fined, my lord, no, my lord, I have now fined, my lord, the division bench judgment of this honorable court. My lord, kindly takes up. Here, my lord, Calcutta bone mills, everything has been considered. Kindly takes up paragraph 40. This is the operating. I will not disturb your lordship regarding the other part. Elaborately, my lord, all the other view, 56 Act, including 1997 Act, every judgment considered, paragraph 40 is the ultimate conclusion.
So Mukherjee, have you given him this judgment?
Paragraph 40 to 30. And the case in hand is under 1997 Act.
Yes,
The case in hand.
It's in his favor.
But apparently, my lord, this is under the
So the
proposition of
issue,
law.
yes, issue is in his favor.
The facts of the case,
Facts
that I
have
have
to be
argued.
gone in.
I have
Facts
argued, my lord,
have to be
that
gone
I have argued. But regarding this, my lord, position of law, my lord, now it makes it clear, my lord, this is the division bench judgment of this honorable court, considering, my lord, the effect of both the acts.
Otherwise, the entire
Yes,
object.
scheme of the act will go.
That is why I told you
Yes,
that it cannot be in that. And where is that judgment of 2015 you have referred to?
That, my lord, has been referred. Every thing has been referred.
No. That the results can be supplied.
That
You
I
have
have handed over. My lord, this
You have
photocopy I have
handed over
handed
yesterday.
over.
No, book you have handed over, not the
While
copy.
taking the book back, my lord, I have handed over.
You have replaced it.
Yes.
Oh,
Assistant.
2015 SCC online. All right. For the learned advocates for the yes.
Item number 3, I'm led by Mr. Dheeraj Trivedi, my lord. The matter came up for extension of interim order, my lord, which expired on last week of June, my lord. We have last occasion we have served, my lord, but the affidavit service is with the brief, my lord, and brief is with.
This is an application for extension.
My lord, can too, my lord.
Have you served upon the other side?
My lord, we have served, my lord. The affidavit service is in the brief, my lord. With
File it in course of this day.
My lord, we will.
On the prayer. Yes.
My lord, let me just explain 2 minutes.
Yes.
পড়েছে নাকি আমি বলছি পড়ে এসেছে নাকি
Lord, point is short, I'll try to make it shorter. My client purchased a flat.
There is no caveat.
No caveat. My client purchased a flat.
Yes.
My lord, the person from whom he purchased the flat is a very well take the possessions. But since an attempt was made to disturb my possessions, my client was compelled to file a suit for declaration injunction from the senior divisions. So I got the injunctions. Subsequently, what has happened? One lady.
What is the declaration sought for? What is the
Declaration?
declaration?
Actually, my lord, I am owner, nothing more, nothing less. Because since a disturbance was made, purchase. One lady, my lord, claiming herself as a wife of the vendor of my client, she filed a suit in the lower division and got an injunction. What are the contentions that were?
She has claimed by virtue of inheritance.
No, she says that, well, I am the joint owner of the property with my husband.
Yes.
Divorce case is going on. So naturally, I am also the owner. So in that suit, he sought for injunctions. I say, how is it senior divisions? You could have filed an application for bringing it as a party. But anyway, my lord, I favor an appeal. I favor an appeal. And both the suits were tagged together. I favor.
Transfer to the senior division.
Yes. Now first senior divisions. I prefer an appeal against that order passed by the junior divisions. Before it was amalgamated. Now appeal court, according to me, I may be wrong, my lord, I must frankly confess, allowed the appeal, but with a rider. You cannot transfer or sell the property. How can you restrain me? Even if I do not sell it, but how can you pass that an order? It is not that other side has come forward and say he should be restrained. Can you take time to look at his order, last one?
Not to transfer is to prevent multiplicity of proceedings.
Now, already there is a.
Because
let them come. Let them come, my lord. I can understand. No cavities, or let them come. Kindly, today, my lord, certainly, my lord cannot grant any stay at the present moment.
Mr. Banerjee, how?
It is my issue. It is my appeal. So, in my appeal, without any prayer, why the court will take the burden and responsibility to pass such an order? Appeal is either added to be allowed or dismissed. But is there. In addition, if there something has been added, which is not desirable and expected, my lord.
So what is the order of the trial court? Please show me that.
Trial court.
Where is the certified copy of the trial court?
No, trial court.
Here, as per the rules, both the courts certified copy are to be.
That I know, my lord. As we had.
But now it's not in none of the matters.
Anyway, every day we are learning, my lord.
Where is this? Where is the trial court's judgment?
Committee
Have you annexed the photocopy?
আমাদেরটা নয় যার against appeal করলে সেই একটা কোন পেজে বিনোটা নয় বিনোটা আমার
Tuned in the miscellaneous appeal.
Yes.
Where is that order?
Volume 2, my lord.
Volume 2, which page?
204 ঠিক বলছিস তো আমার বেইজ্জত
204
করি না তো তো মিস আপিলের কথা বলছিস
No, 204 is
try to
something
understand
part of the deed.
against which you paper and miss আপিল সেটা কোথায় আনিস
No, I don't think. Please show me the trial court's order, even if I have not annexed. Because this
Trial
order
court-
records it has been modified.
I'm just
That. So, modifying, retaining a portion, it's permissible in appeal.
kindly appreciate one aspect.
Mr. Banerjee, if you are injuncted not to transfer not to disturb, let us take for that, not to disturb the possession, not to transfer such and such. Now the appeal court can modify with regard to one retaining the other.
Kindly come
So
to
please show me the trial court's order.
103,
103.
volume 1.
Yes, so this is permissible because the trial court
I'm
passed
coming,
an order
I'm
of
coming, my
status
lord.
quo
Just
with regard to the property, which includes
kindly-
everything,
Kindly come to 104, my
nature
lord.
and character.
Yes, yes, I'm coming on 104. That the temporary injunction application order 13 to reduce section 151 is hereby allowed on contest. Plaintiffs and defendant number 3 and 4 are directed to maintain from the status quo in respect to the suit property till the issue of the suit. Thus, the injunction application status quo. Nothing more, nothing less.
Status quo, what is the meaning of
No, but
the
no, my lord, one thing.
status quo is everything. The present status is to be
I could-
maintained. So the property in whose favor it is there, no further, it's
I-
broad.
no, I-
It's broad. The appellate court has reduced it, has made it shorter. This is
kindly bear me for a moment. Status quo order was passed by the court at the first instance. I was aggrieved. I favor an appeal. Appeal court allowed the appeal. Once it is
allowed the appeal.
Yes.
Yes, allowed the
At
appeal.
the same time,
modifying that. So it's part allowing.
No, my
It's
lord,
modifying. So retaining part, setting aside balance.
what is modifications? Kali marked, my
Sir
lord.
Banerjee,
Then in one hand, I've got the order, in other hand, it is snatched away.
Part allowing is always permissible.
Is it really part allowed?
Yes.
I'm asking myself.
Because
Status quo.
everything you can do, but except transfer, because is restrained from disturbing the possession of the appellant. So that you have got, but with regard to transfer, you cannot do.
Whatever you think, Pete.
Uh,
As your lordship, my lord.
Yes,
My lord, I am appearing on behalf of the petitioner, my lord.
yes.
The fact of the case is that the petitioner has instituted a suit for cancellation of deed and declaration and injunction
What
against
is the order impugned?
my lord, if your lordship kindly travel to turn page
The nature of the order which you are
my
challenging.
lord, the honorable division bench, the matter is how it was heard by the honorable division bench.
First of December 2017 order you are challenging now.
My lord, page 82. Honorable division has given a liberty, my lord. Paragraph 11, my lord. 84, page, paragraph 11. May I permit to read, my lord?
Yes, what is the order? Where is the
Impugned order.
yes?
Page 64.
First of
45.
December 2017.
45. My lord, may I be permitted to read, my lord? Page 64. Order number 45 dated 1st December 2017.
Yes.
Today is fixed for show cause and cost. Both the parties file hajira. No show cause filed by the defendant. Neither the cost is paid by the defendant. The learned appellate court has observed in his order that the only on payment of cost rupees 5,000 by the defendant, the impugned judgment and degree shall be set aside. As the defendant did not pay any cost, and as they are not even moving before the court, hence the impugned judgment and degree remains valid. But the case be dropped as the suit cannot be proceeded anymore. The non-payment of cost by the defendant. Thus, the impugned case will be dropped, my lord.
Yes. Then what did you do? You have challenged this order.
Yes, I have.
In appeal.
In appeal, I have already challenged the appeal, and appeal court has. First of all, my lord, my suit, I have filed a suit, instituted a suit against the defendant. Defendant costed the suit, and said suit was dismissed. Subsequently, we have preferred an appeal, and appeal court was given appeal was allowed and given liberty to file. Appeal was ordered the rupees 5,000 to be paid by the defendant respondent to the petitioner. That is the crux of the matter. The defendant paid to be defendant has to be paid to the petitioner rupees 5,000. Thereafter, defendant has not paid. And if your lordship kindly trouble to turn the order 44 of the learned trial court, my lord, kindly order 44, my lord, the learned trial court has issued show cause notice against the defendant. Why the suits are allowed to be exported run, my lord. Page 63.
Where is the order passed in the first appeal?
Yes. Page 51. Page 51, my lord. 58, last order portion, my lord. My lord, got it? We have also, my lord,
Petitioner is directed
Interim stay, my lord. Interim stay.
What stay? To dismiss what stay? Yes.
My lord, the petitioner here, before your lordship, is the defendant in a suit for partition. My lord,
What is the order which you are challenging?
my lord, by this revision and application, I have challenged two separate orders. My lord, first of all, the order dated, my lord.
10th of February 2026.
No, my lord, 17th April 2025. And my lord,
17th of April 2025.
my lord, and then 10th February 2026.
Yes, what is 17th April 2025?
My lord, by that order, I am the defendant in a suit for partition.
Defendant in a suit for partition.
My
Yes.
property is well demarcated, well separated, separate holding number, and my assessee number. After purchase, I started making my construction upon production of the, upon obtaining my sanction plan. And when my construction work is going on in full swing, he filed the suit for partition. Initially, the opposite party number one, the plaintiff in the suit for partition, was a lessee. In this,
So what is the order dated 17th of April?
by that order, the petitioner was directed to produce my sanction plan.
Yes.
I'm not challenging that order. We filed an application under section 151 for recalling of that order. My recalling application has been rejected by the order impugned 10th February 2026. That is why both the order under challenge.
Oh, 17th of April, you are directed to produce the sanction plan.
My lord.
So you have paid for review of that order or recalling of that order.
My lord. That
was rejected.
That has been rejected.
What is the difficulty in production of your sanction plan?
My lord, I'm telling your lordship, my property is altogether separate holding. The owner of the opposite party number was the owner of premises number 15, Rani Harshamukhi Road. I am the owner of the premises number 15/1. Altogether separate. I have no connection with that premises. And my lord,
what is the difficulty in producing the sanction plan?
I am telling you, lordship, what is.
You have a sanction plan.
Yes.
So produce that. What is the difficulty?
At the time of hearing injunction application, that was produced. Upon considering my application, the injunction.
Please show me from the injunction application that was produced and considered.
Yes, it is the order. They obtained the expiry order of injunction. We preferred appeal. Appeal was allowed. Their prayer was rejected.
Raut, what is the difficulty? If you have produced once, you can produce that. Only the court requires. What is the difficulty in producing?
So far, that document is concerned, there was no relevant.
Maybe only the production.
Yes.
The court may be satisfied it's not relevant. Compliance will be there. That's
at the time of hearing injunction application, upon taking into consideration my.
Mr. Raut, if you have produced one, what is the difficulty? For that, a civil division. This application under Article 227.
My lord, I take to appear on the
Yes.
petition.
Who are you?
I'm the defendant in a testamentary suit, my lord.
Yes, what
My
is the order under challenge?
Yes, my application under Order 26, Rule 1 for evidence on commission has been rejected by the impugned order. Your lordship will kindly see.
You are for the caveator.
My lord, I was delayed by 2 days in filing the caveat. This petition had already been filed. I have not been served. If your lordship does decide to admit,
Let me
then-
see whether he can cross the first hurdle.
Lordship, please.
Yes.
Your lordship, this is a testamentary suit. I was the objector. There was a specific point taken in my written statement in paragraph 39 that I have received information that the testatrix had put some signatures on a blank paper, and the plaintiff has obtained that, and that information was supplied to me by the maternal aunt of my husband. My husband has expired. I'm the widow. Now I seek to bring that old lady from whom I have received that information as a witness. Now she is 85 years old. I have made an application under Order 18, Rule 16 because the evidence of PW1 was already going on. And along with that, I have made this application for Order 26, Rule 1. Both were heard together. Now, my application under Order 18, Rule 16 was allowed, stating that yes, there is urgency because she is an old lady. She is suffering from osteoarthritis. But at the same breath, the court has come to a finding that the medical certificate which I have produced is not sufficient to ascertain that she is unable to
Where's
come
the
to
medical
court.
certificate?
Yes, at page 57, your lordship kindly sees. She has been suffering from severe osteoarthritis. She is unable to move anywhere for any purpose. This is dated 7th of February 2025. My application is of 2025. Now, your lordship, may I place the impugned order, your lordship?
Where is her residence?
This is Dom Dom. And court is at Alipur.
Doctor came to her residence or she went to the doctor's?
Doctor came to her residence. The doctor always comes to her residence. Now, there is 2 points on which the court has come to this conclusion. First is that that was not sufficient, the medical certificate. And second is, in my prayer in my application, I have indicated that while the commissioner goes to the residence for taking evidence, the commissioner may take her evidence in chief from the record of the court. Her evidence in chief has to be filed prior to that. So there is a prayer that he will be permitted to take that evidence in chief and
from the record means I could not.
From the record of the court.
She has filed the chief?
No, not yet. It will be notary on commission. The chief will be prepared. It will be notarized through commission and thereafter filed. Usually on the date.
Show me your application under Order 26.
Yes. My application is at page 53 and your lordship will find the prayer at page 55. It is therefore prayed that the learned court may graciously be pleased to allow this instant application by appointing an advocate commissioner for holding the commission for examination of Mrs. Reena Sannal on the basis of the evidence in chief, and to authorize the learned commissioner to take with him the evidence in chief of Mrs. Reena Sannal from the record and to pass such order or orders as your honor may deem fit and proper. Now, there is no difficulty in filing the evidence in chief. The witness is not required to be present at the time of filing of the evidence in chief, the affidavit in chief.
What do you say, Mr. Chatterjee?
No, if
he has
it is
to
being
depose saying.
No, she is not. That is not. It
Yes,
usually
but
happens that it is filed one.
Age is not a factor. There are persons more than 85 regularly attending court.
Coming to court.
So age is not a factor, but the disease which has been said and the.
May I kindly place one thing before your lordship? One is, if your lordship sees the medical certificate, this is a medical certificate where the doctor comes to a conclusion without any sort of test, without any sort of imaging, without any sort of X-ray, and does not even prescribe medication.
Physical examination the doctors
Lordship,
can arrive at. Tests are to protect the doctors from any further proceedings.
May I, my lord, kindly
because the best examination is the physical examination, and the previously where were those tests?
No, my lord, may I kindly place
couple of facts, my lord. Thereafter,
Are you
I leave it to you.
disputing this fact?
I
that,
am disputing. I am disputing
Who are
the
you? You are
fact.
also a relative.
I am the plaintiff. I am the plaintiff.
So you
I
are also related to that lady.
Miller-
So you must be knowing the physical condition.
Yes.
That is what I'm asking you.
Which is why.
Okay, if she is not at all in a position to move out,
Lordship,
then,
if she is
what will
not
be
at
the
all,
difficulty? On commission it can be done.
Lordship, if she is not in a position to move at all, then I will not stand in the way. But may
What
I?
is your instruction?
My instruction is that we can provide an ambulance, a car. Certainly, if she can come from Joshua Road to Alipur in a car, in an ambulance. Milord, secondly,
She can come. How do you say that?
Milord, because her movement, your lordship sees para 4 of the impugned order. Your lordship kindly sees para 4 of the impugned order.
Yes.
Second paragraph. This is a spanner in the wheel. The written statement was filed after a year.
Paragraph 4. Yes.
Page 4, my lord.
Page 4.
The paragraph starting with though the doctor's certificate.
Page 4, sorry. Page 4. Yes, though the doctor's certificate.
Though the doctor's certificate suggests that Mrs. Reena Shandal has been suffering from osteoarthritis, she is unable to move, but it fails to suggest that her movement is completely restricted, or nay, she is completely unable to attend court. I get support when I find that it is prayed in the instant petition that her evidence be recorded by the commissioner after taking her affidavit in chief from the record. My lord, all that I am praying is, if she is examined by...
This is also affidavit in chief from the record. That's confusing.
Because
what do you mean to say by that?
Because I will usually what happens, your lordship, a person
Yes,
who can come to
I direct him to serve a copy. Can you take instructions? If she is really in a position not to move, maybe she can move, but
cannot, and that is not something which has happened recently.
Sir, I am submitting on instructions. I am submitting on instructions, my lord. What has happened is the plaintiff's son is there with me. He is a relative. The plaintiff and her son are both here in court. They are saying that this medical certificate that has been made, I am not disputing whatever one doctor has said. All that I'm saying is at my expense, let her be subjected to some sort of imaging, some sort of test by an institute of repute. For example, Quadra.
This will ultimately delay the proceedings.
Lordship, she is...
If it will ultimately delay the proceedings this way or that way, to avoid that, if the commissioner is appointed on a particular date, that will be done.
Your lordship would see.
And then the other thing is that Order 18, Rule 16 is to give
that
her
has
first.
been
So
challenged.
that can proceed simultaneously also.
Lordship.
So the other evidence can also proceed. Mr. Chatterjee, you cannot stop that.
I am not stopping that.
So
If the
that will also proceed.
learned court wants to proceed, then
Today I did
I'm
not
standing
wish
in
to-
the
Can be proceeded.
Today I did not wish to give a background, but if your lordship may
there
permit
is
a
some
minute.
difficulty with regard to
I
proceeding.
don't want to know about the background, only with regard to this fact.
Lordship,
Whether
there may be some
there is
difficulty
a-
in proceeding with
there
the
is a-
plaintiff.
please
witness. May I
take
just-
instructions. I'm keeping it. Mr. Chatterjee, please give her.
Yes,
give
I
it.
will.
There, my lord, the matter is on the suit is on 22nd July, and which is why, my lord, their entire idea is to
No,
put a spanner in the wheel.
No, there
22nd
is
of
already may I
22nd of July is for what?
For
for
example,
hearing of for hearing of amendment application. They have filed an amendment of the plaint.
evidence. For
I have
evidence
annexed that
of the
application.
concerned lady, Mrs. Shamnal.
No.
No, that is
16th
their
of May
also
for
their
evidence of Reena Shandal for hearing of the
Lordship.
amendment dated.
they are your lordship will kindly see
Amendment
page
application
68.
has been,
Kindly see page 68. I have
amendment
annexed
application is there.
that. Yes,
Please, Mr. Chatterjee, please give him a copy. Please come tomorrow.
I was
On 29th
Yes.
of June, another order.
lordship
Uh,
keeping it tomorrow.
The petitioner is,
Keeping it tomorrow.
yes, your difficulty. The petitioner is directed to serve. Instructions, your instructions are inside court. So I'm giving you the time to go through the petition. Yes.
Item number 8, I am praying for not today, lordship. I am praying for not today, item number 8.
Please don't pray for not today, please. move
Lordship,
this
the
matter.
recorded
What is this
advocate.
matter? What have you prayed for?
Lordship, I am not the recorded advocate. He is not available due to some family emergency, and I also don't have the brief, your lordship.
This application under Article 227 of the
Partition suit, my lord, pending before the Sri Judge
What is the stage of the proceedings?
proceeding, my lord, I have given. a-
Injunction application. This application under Article 227 of there is no one to propose whom we will oppose.
My lord, he can also propose, my lord. He's a part of the petitioner, my lord.
My lord, I'm
Who is the part of
Mr. Mitro.
Oh, you are for the petitioner?
Yes, I'm for the
My lord,
petition.
first I'm taking, my lord, this from a first miscellaneous appeal. my lord.
Yes.
My lord, trial court has, appeal court has fixed the matter on the 12th of August.
Miscellaneous appeal hearing. So Mitso, you are appearing for?
My lord, incorrect, my lord. I'll just answer him. The date was on 24th June 2026 for him to file an objection. Intentional delay, no objection filed.
What is the next date for hearing?
12th of August.
Miscellaneous appeal is otherwise ready for hearing. What are you aggrieved against?
My lord, I am aggrieved against, there has been injunction passed against my property, ex parte.
By the trial court.
By the trial court, this situation has been continuing since 1986 at the earliest.
All parties have entered appearance in the miscellaneous appeal.
Yes.
Yes.
All parties
My
are
lord knows
both
Gautam
the-
Hara, my lord.
Sir, only one thing. There is no scope to stay an order of injunction
And I've got the judge.
prior to the hearing of the appeal. So I can only direct the
But
appeal to
expedites
be
it.
disposed
I
of.
don't have a problem.
For the next, what is the next date, please?
I have got only one submission. But I am not going to take your lordship into the merit of the controversy, the petitioner will do. First is suppression of material facts. One of the most important document has been suppressed
By the plaintiff.
by the plaintiff at the time of obtaining the interim order. First that, and secondly, one of the delay. 42 years, this particular so-called trust had been sitting over there, never interfered with this. After 43 years, they are coming forward before your lordship and saying that, look, I am the owner of the property. I am the trustee. Without reference to me, how have you transferred this property? The flats in this particular property have been transferred on numerous occasions, hundreds of occasions. Various people have come in, not a whisper for 43 years. I say that after all, you are obtaining an equitable relief. Your application should be dismissed on the ground of delay.
But if he has an appeal,
Mr. Mitro, there are two ways of looking at it. One is, yes, you can, the proposition is ordinarily stay should not be granted in a miscellaneous appeal without hearing the other side.
Right.
So after hearing all the sides, stay may be granted on the miscellaneous appeal. That will unnecessarily delay the miscellaneous appeal because the main appeal is to be heard. There, if you succeed, you succeed.
And he has his appeal pending.
Because there are two ways. One is, it's an ad interim order of injunction. So if it is an ad interim order of injunction, the main temporary injunction is pending.
Yes.
So, one thing can also be done, because this is the ad interim. So all of you are fighting with the ad interim. So without fighting for the ad interim, I can also direct the temporary to be disposed of within a certain
I
time.
am only submitting this, that for 43 years you have not done anything. Today, by almost, my lord, by way of a side wind, an order had been passed restraining, my lord, the owners of the flat, the persons who are in occupation of the flat, from dealing with the flats altogether. This is, well, this, my lord, shouldn't have been done, my lord.
Two courts have allowed this, my lord.
Mr. Mitchell, I appreciate, but there are two views on what is the scope of an appeal from an ad interim order of injunction.
I quite appreciate
One
that.
says very limited scope. One says, yes, you can bring those suppressions, which you are saying that those documents you can also bring in the before the first appellate court in the miscellaneous appeal. You can
That
also bring
judgment has
that.
also been referred now.
So there are two views. One says scope is
Jitendra Prasad Pandey and my lord, Bengal Club has now been referred, my lord.
yes.
It has
So
just-
now, so there are two views. So instead of going to that, so you can take all points in the temporary injunction
Of course, I
application.
will take all points, my lord, whichever.
I can expedite the hearing of
Mr.
the.
What I am aggrieved about is this, that this particular trust, who had been holding the property only for the, at the instance and for the benefit of, my lord, the individual flat owners, they have obtained by way of a side wind an interim order by which, my lord, the entire thing has been stalled. Well, this is something, my lord, I respectfully submit to your lordship, the trial court should not have passed on. The trial court should have said that, look, you have waited for all these years, give a notice to the other side, after hearing the parties, that let the affidavits be filed and there. Ad interim order of injunction after 43 years. Well, this is
I appreciate, but the best thing I think would be to relegate to the trial court. If you accept that you will not be proceeding with the
Well, he has a
miscellaneous
separate appeal, my lord. So he has
because
to
it's
consider.
your appeal.
No. My lord, he has come up from a separate appeal. He has a separate appeal. He has not come up from a separate appeal, my lord, from the.
I am supporting the appellant, my lord.
But it's separate.
So if the
All that
appellant,
is
if the appellant says that he will not proceed with the appeal, so I direct the trial court, you file your written objection within a certain time. What is the next date fixed to the trial court? Because then the temporary injunction can be disposed of. Otherwise, you will be fighting with the ad interim. Court may say limited scope. All right. So again, then temporary, it will delay.
Respectfully submit to your lordship, kindly give here, my lord, the petitioner. First of all, my lord, let the petitioner come before your lordship and tell your lordship what the facts are about. Because, my lord, I happen to be, my lord, the respondent number 7. So, my lord, naturally, my learned friend is taking advantage.
I'm not taking any advantage. My lord, if he wants a time, I don't have a problem with it.
Yes.
Take advantage.
Yes, sir. What do you say? If I relegate to the trial court, all the parties, they can.
Mr. Banerjee is appearing in this matter for the petitioner. Your lordship will kindly, my lord, take it up tomorrow if your lordship.
Which Mr. Banerjee?
Which Dr. Ankuban.
Also,
He's very busy. I know that, my lord, he's very busy. But
Not more than
I
you
am, my lord, holding the cudgels on his behalf, but I am not entitled. I frankly concede that. But, my lord, I have got a lot of things to say to your lordship on this particular application.
But only thing is that whether because the appellate court has also not has not decided. So really, I will be scrutinizing the decision of the trial court when the appeal court is insisting. That's what is troubling me. That's what is troubling me. So then any of you might be losing one forum.
Well,
Any of you might be losing one forum then.
Insofar as I am concerned, I am quite happy before your lordship. Let me use all the forums.
So that's the only thing which I was thinking of. If it can be relegated either way, either the appellate court to dispose of the miscellaneous appeal, that also can be done, or the trial court, because this is the ad interim. If you want the appellate court, I can also direct the appellate court to dispose of not you, through you, him.
Dispose of for a trial court.
Now he's the petitioner now.
No, he was siding with Mr. Mitro.
No, just now he has been told he's a for the petitioner.
World Cup is going, Lordship.
What is happening, my lord? But it's Egypt and Argentina, my lord.
Yes, Mr. Ghosh, you are appearing for the petitioner.
No, I was.
It's for the response.
I am the.
So you can also appear for the petitioner.
That I do.
My lord, they are part of the syndicate for which Mr. Mitro is appearing.
The matter, if he has changed his color, my lord, I don't know in the meantime.
Yes,
My
what
lord,
do you
may I
say?
suggest one thing? Keep this matter tomorrow. I am led by Mr. Banerjee. I would like let him make his submissions.
Keeps it tomorrow, my lord. I will just point out, my lord, I have a part matter tomorrow. And if I'm for some reason, my lord, I'm on legs, my lord, kindly passes it over for some.
Who is assisting you, Mr. Rai? You are a senior advocate.
My
You
lord,
cannot be alone.
my lord, my 3 juniors are here, my lord.
So they are
But
well
they might be, my
competent.
lord,
They are very competent. You can join them.
But I'll join. But if my lord, push comes to a shove, my lord, kindly just passes it over for something.
তাহলে
সেটা আমি রাখতে সোমবার করো আমার কোনো অসুবিধা নেই।
তাহলে হ্যাঁ এমন একটা দিনে one of you
Sorry.
will say that I
Well,
met him.
Monday.
Well,
Yes,
Monday the monthly list, so Tuesday, my lord, I think that would be better for them. My lord, monthly list, so that's why I'm saying. That's better. Ali.
After some argument, the learned advocate appearing for the petition.
So you kindly make it Tuesday.
Tuesday.
Tuesday. Yes, next.
But very grateful.
Tuesday ঠিক আছে?
হ্যাঁ, sir. Thank you, sir.
Yes.
This is for my expeditious hearing of the suit, my lord. This is a money suit, my lord. But filed in 20.
What do you want?
At expeditious hearing of the suit, my lord, there was initially, my lord, but a so-called written statement has been filed after 2 years, my lord. That was also.
But that rule 1 and 2 is still pending.
My lord, that was, but I have withdrawn that, my lord.
You have
I have
withdrawn
withdrawn
what are
that
that rule 1 and 2 when?
24th June 2026. That order is not there, my lord. But I myself has withdrawn that, my lord, so that I can expedite the suit, my lord. That I have done, my lord. You're looking at it.
24th of June.
Yes, my lord.
2026.
Yes, my lord. And next that is fixed
So
for
that injunction has been withdrawn.
withdrawn by me, my lord, by the plaintiff.
Now what is the next date fixed?
18th of September 2026.
For what?
For framing of issue, my lord.
For framing of issue. This application under Article
Interpret.
12 years, yes. Pass over next.
13 minutes, I am for the petitioner. But very
Yes.
short point. My father died immediately on getting this substituted summons, my lord. I entered appearance and filed application under section 151 reduce section 7.1 and 151 reduce section 7.2 because I have to deposit the current rate. That application has been rejected.
So your father did not file 7172?
Yes, that
Then
is pending.
how can you file? How can you file a separate 7172?
But I have to deposit the rent.
That application is pending.
No, the 7-1 is disposed of.
Yes.
Of my father. But the second time, when I have entered appearance,
Where is the scope of filing separate applications
no,
by the
no.
substituted?
This is not at all 7172. This is an application under section 151. Reduce section 71.
Under what provision? You have to go on complying with 7.1. 7.1, there is no necessity to file any application.
But
you have only to deposit.
But since my application is rejected, I have not been permitted.
You have taken that risk. Where is the provision for filing an application?
There is an old judgment, on this point. I can deposit, 7.
Deposit according to your wish.
Kindly dispose of my divisional application that I will continue as per my father's prayer, and my father's 7.2 application is pending. Kindly
pending. So why have you filed another 7.2?
Not another 7.2.
Where is your 151? Please show me.
Kindly come to page 33. I have said that my father's application is pending.
Yes. So proceed with that.
Kindly dispose of that. I will proceed with that.
Yes.
And if I am not permitted to deposit the current rent, then it will be fatal.
Yes, 7.2 also you have filed 151. 7.2.
Read with 7.2 and para 13 of my application at page 37. My lord, I have made it clear that I want to deposit simpliciter. Forget about the nomenclature. I want to deposit the current rate. That much I am entitled, and I will adopt the prayer of my father in the 7.2 application. That much I can. But my lord, dismissal of my application under section 100. I am the defendant, substituted defendant. I can take defense. Otherwise, the impact of the order is that from tomorrow I will not be allowed to. Order 22 rule 4, my lord, sub rule 2 empowers me to take defense appropriate to my character. At best, my lord, I can adopt the defense of my father. But my lord, if I am not allowed,
you know what you can do.
But
only thing is that you have created complications.
The impact of the order impugned is that I will not be permitted to deposit the current rent. That much kindly give me protection that I will comply with the father's order. 7.1 order. I will be happy. Simplicity, my lord, when I have been substituted, I have made this application.
When your father filed the application under 7.1?
My lord, that is within time. That is pending. 7.1 was allowed, and my father was depositing. On the death of my father, I have to deposit the rent. So the point is, under what provision of law I will deposit? The old.
That you have to advise, Mr. Rai.
My lord,
that you have to advise. This application under Article.
Kindly.
I will not say anything. What you can, you do. This application.
Other
Create any confusion. You have created the confusion by filing this. Yes.
My lord, I am for the opposite party, my lord.
Yes.
Again, after a long time, my lord, I am for the petitioner, my lord. And kindly enough, if your lordship kindly peruses the impugned order, your lordship will be very much surprised. My lord, by allowing petition under Order 6, Rule 17, there is an imposition of 10,000 cost by showing the reason that we have delayed the matter. My lord, kindly see page number 55, my lord. We had prayed for expeditious trial. Kindly see.
But your prayer for amendment was allowed.
Yeah, Lord, by
Can you challenge a portion of the order?
Yes.
Conditional. Please show me that.
Yes, my lord. Kindly see, my lord,
the provision, if the order is a conditional order, you can challenge a portion and accept the other. Please show me on that. No, first. Second is, if you accept the other way around, if you accept the order allowing the amendment of plain, can a revision application or a revision application is maintainable against an order directing imposition of cost? Please satisfy me on that, whether a civil revision application simply considered on the ground of imposition of cost is maintainable.
Oh, my lord, yes, I am. You are justified, but there can be no revision application challenging the order of cost.
It boils down to this. When you say you are not agreed by the order allowing the amendment, there are two ways. One is conditional order. You cannot separate that. It's a conditional order.
Yes,
you cannot say one thing. Yes, I'm accepting. The other thing, condition, I'm not accepting. You cannot do that. Even if that argument of yours is accepted, so merely it becomes a revision against cost. That also you cannot do.
One thing, my lord, kindly. One, I shall take 2 minutes time. The trial court will
take 3 minutes of time. But please satisfy me on this.
The trial court has assigned the reasons that we have delayed the suit.
I appreciate that, but
we have
but how a revision application is maintainable? Please enlighten me on the point of law.
Yes, my lord. Yes.
Cost against cost.
Against cost, but 10,000.
I can do one thing. I can expunge the observations. Please pay the cost.
My lord, cost is very burdensome, my lord. Unnecessarily, my lord. And cost regarding, my lord, there was just in the plaint Munni Chaudhuri, just his name was Bensal. And that's typical mistake, my lord.
Yes, what do you say?
My lord, let them serve a coffee.
Copy I am solving.
Only with regard to the cost.
My lord, the cost has to be paid, my lord. The cost has to be paid, my lord.
Want some reduction? What do you say?
My lord, there are several matters they are coming up before this honorable court. Previously, they have come before this honorable court.
That's all,
saying on the revisional application, my lord. Against
civil revision applications are pending.
Lots of matters.
Then you can pay this.
What?
Then you have
only 2, my lord. He is indulging in blatant lies. There is an appeal, my lord. Civil division only 2.
Only 2 civil division, then you can pay 10,000.
My lord, 10,000 is huge burden because unnecessarily, my lord. Kindly see, my lord.
In the High Court, you should not come against the cost of 10,000.
My lord, kindly, one thing, my lord. They are saying that I have delayed. I have not delayed.
All right, I expunge those observations.
And cost, my lord, kindly, my lord, reduction and also. Oh, yes. There is the client, my lord, is very. He has been absorbed in so much
the client. Please don't exhibit the client.
No. I am seeking forgiveness.
Yes.
But only my ambition, please reduce because unnecessarily we are being harassed.
Ashun, this application under Article Yes.
With permission, my lord.
Thank you.
After a long time, I have come before.
And for the petitioner, my lord, praying for expeditious disposal of a partition suit, my lord.
What is the stage of the suit?
My lord, the evidence of plaintiff witness number 1, plaintiff witness is going on. He's a 69 years old man, my lord. For
This
last
application
16
under Article 226.
I beg to appear for the petition.
Yes.
Alimony pendenti light filed under a matrimonial suit for restitution of conjugal rights.
Who are you?
Petitioner husband.
Yes.
By that order, 3,000 for the wife and 4,000 for the minor child has been passed. In a parallel proceeding under
1000, do you think that it's
Mason,
excessive?
Lordship Mason working at construction site. Purbo Mendipur.
The amount, 3,000 for the wife.
And no, I am not on the 4,000. Formal education of the child has not yet begun.
What is the age of the child?
5 years.
It will start. Please start paying. Ashun, this application.
No, the husband's mother.
You have to maintain the father, wife, child, everyone.
Lordship,
This
under
application
PW Act, I 5,000 I am already paying. The PW Act separate proceedings.
This will be adjusted. If you make
Lordship,
that will be adjusted.
Lordship,
This
even
application
it can be reduced to 1,000.
This application 1,000 is nothing. For 1,000, High Court, yes. Should have said 3,000, 4,000, yes, it could be under.
5,000 I am already paying.
Application under Article Yes.
17, my lord, I appear on behalf of the petitioner, my lord.
Yes.
My lord, in a suit,
Plaintiff or defendant?
plaintiff, my lord.
Yes.
Suit for, my lord, declaration and recovery of khas possession, my lord, the defendant, my lord, adduced a witness summon. My lord, that witness summon for the first time, my lord, gave the evidence, my lord, that my dag number has been recorded in a separate khotiyan.
Your plot?
My plot.
What is the suit?
Suit for declaration, my lord, plaint is at page 13.
13.
13.
What is 9?
9, my lord. Same, my lord, same amended plaint.
Amended plaint?
Yes, my lord.
This is the previous amendment?
No, same, my lord, both has been.
No,
twice it
there
has
are
been
two amended plaints.
No,
Page 9 is one amended
that is
plaint.
the photocopy of page 9 only. Page 13 is the photocopy of page 9
Same
only.
thing.
Same thing, my lord.
Yes. Page 13.
Page 11 is the schedule, my lord.
Page
11. Page
you
11
want to
is
rely upon the first one? Yes, page 11 schedule.
schedule, my lord. In
Yes.
district Bardhaman, subdivision PS Durgapur, Mouja, Thandabad, Khotiyan number 3098.
Yes.
Sabek plot number 629, Hal plot number 1034, measures 2 kata, 14 chatak, wrongly recorded as 3 decimals, surrounded by Pakka boundary wall. The land measures 3 chatak, Sabek plot number 625, Hal plot number 915, measures 3 chatak, situated outside the boundary wall. Now, Lord, kindly comes to my amendment application.
No, I could not follow this. In district such and such, Hull plot is 1034.
Yes, my lord.
Measuring 2 katas, 14 chitaks, wrongly recorded as 3 decimals.
Yes.
Surrounded by Pakka
Boundary wall.
The land measures 3 chitaks.
Comprised in, that will be comprised
So
in.
there is a property inside the boundary wall as
And
well as outside the
as well
boundary.
as outside the boundary wall.
That is 3 chitaks, 625.
Yes, that is the Sabek plot number 625. And now, my lord, the Hal plot number is 915.
Yes. So 2 plots.
2 plots, my lord.
One is 1034, another is 915.
915.
Yes. Now what happened?
Now, my lord, kindly, my lord, comes to page 17, my amendment application.
Oh, you have applied for amendment. Yes.
My lord. Page 18, para 3 onwards, my lord. Para 3, my lord. The learned trial court has been pleased to fix the date for evidence of the suit. At that time, the
Please kindly come to the proposed amendment.
proposed
To incorporate the words LR plot number, to incorporate after the words LR plot number 1034 and 915, wherever appeared in paragraph 2, the following words and sentences. What is that? Subsequently renumbered as plot number
1107 by 1155 and LR plot number 1106 respectively, and LR plot number 1106 recorded under revised LR Khotiyan number 2332 stands in the name of the plaintiff.
No, you are not changing the plot.
No, I am not changing the plot.
So what is the necessity for this?
No, Milord, this is a suit for recovery of possession, Milord. They will
Yes.
take this point, Milord, while I am executing my if I get the degree, Milord. They will take this point, Milord.
What?
For proper identification of the scheduled property, Milord. They will take this point, Milord, for proper identification of the scheduled property. Well, it is their witness who has come and adduced, Milord.
Show me the evidence.
Yes, Milord. This is, Milord, the exhibit B. This is, Milord, the exhibit.
No, where is the statement in the evidence?
Statement, Milord, that I need to find. That from the staff of the BLRO office, Milord, came and deposed, Milord, as witness summon. That, Milord, he produced, Milord, that was exhibited as exhibit B. That LR record, Milord.
Yes.
Milord, kindly, Milord, sees that is under 1 Khotiyan.
Yes. 2332.
Yes, that is the new Khotiyan, revised Khotiyan, which has been created in my name, Milord, without giving any notice, Milord. This was, I first came to know
why. Challenge it here.
No, Milord, I am not challenging. I am just incorporating. I am just incorporating the fact.
No, incorporating in this way, you have not said that that has been recorded in this. That's not your amendment.
Yes, the para 4, my lord, para 3 and para 4, my lord, kindly, my lord, comes.
Para 3,
Para
no,
3.
para 3 of which page?
Page 18, my lord.
Mr. Mondal, this will not go into the amendment. What will go into the amendment is the schedule.
Schedule, my lord, schedule.
Please show me from the schedule you have clarified that. This has been subsequently renumbered.
Subsequently, my lord, page 20, my lord.
Yes.
Subsequently, my lord, after the words, my lord, to incorporate after the words LR plot number 1034 and LR plot number 915, wherever appeared in para number 2, following words and sentences, my lord, subsequently renumbered as plot number 1107 by 1155 and LR plot number 1106, respectively, and LR plot number 1106 recorded under revised LR Khotian number 2332 stands in the name of the plaintiff. And my lord, the second part, my lord, to the schedule of the plaint after the words and sentences Shabek plot number 629, Hal plot number 1034. The following words and sentences to be incorporated. Shabek plot number 629, originally recorded as LR plot number 1034 and subsequently renumbered as LR plot number 1107 1155. And Shabek plot number 625, Hal plot number 915, the following words and sentences to be incorporated. Shabek plot number 625, originally recorded as LR plot number 915 and subsequently
Where is the written statement? Please show me the written statement.
Statement, my lord, not annexed.
Please give me a copy of the written statement. What is the impugned order?
Impugned order, my lord. Last page of your lordship's brief, my lord. My amendment application was rejected.
Yes, please show me the written statement.
Lord, the learned trial judge was of the view, my lord, if some statements are made by the DW in course of his evidence, then the burden of proof regarding such statement is on the defendant, and on no such burden is upon the plaintiff for adducing evidence in this regard.
So you are not relying upon their statement, their evidence.
Yes, my lord, they have exhibited the document.
Are you disputing this?
No, I am not disputing.
Then
I am accepting, my lord.
So you can rely upon that at the time of.
My lord, my scheduled property needs to be properly identified, my lord.
Tomorrow, if it is changed, please take a case after the evidence is concluded, after the argument, plot number is changed. Another Khotian, you will again amend. What's the law on this? You will have to keep on amendment, or you can relate this at the time of evidence. What's the law?
But that will. But I get your lordship, my lord.
And after the suit is decreed, at the second appeal stage, the plot number is changed. What you will do? You get a decree. So that will be reversed. You will again amend your plaint. From the trial court, it will continue. Start. What's the law on this?
Milord, but there remains, Milord.
I'm asking you, please answer me on this.
For that, Milord, I need
Property erroneous description, Mr. Mondal, it can be corrected at any point of time. This is not an erroneous description. This is the change number.
Change number. Milord,
So
for
change number, you can only satisfy at any stage. At that stage, you have to satisfy.
Yes, Milord,
It's
now
not-
it's the stage. Now it's at this.
That is what I'm giving. I'm telling you, not by way of an amendment of plaint. Not by way of an amendment. That is what I'm telling you. So if at the second appeal stage, the plot number is changed, new Khotian is done. So your decree will go.
Decree won't go, Milord.
What?
Then, Milord, I need
Then
to
what
take-
you will do?
I need to take,
What you will do?
Milord, I need to make amendment, Milord, to the
Of what?
the execution, Milord, the execution and the plaint also, Milord.
Plaint, so the decree will go, property will change. Property will change then. If you amend that, what will happen to the decree?
Decree won't get
Then-
frustrated, Milord.
Then,
Decree won't
if
get
that is not frustrated, how it will be frustrated at this stage?
No, Milord, kindly, Milord. Milord, they will take this point, Milord, while I am executing. If I get the decree, Milord,
That
they
is
will
what
take.
I'm telling you. So the decree will not go. So what you will do then?
Milord, I need to again come up before your lordship, Milord. They will.
For what?
Milord, they will file a section 47, Milord, for proper identification. For want of proper identification, they will file, my lord. If I get the decree, when I'm going to levy execution, my lord, they will file, my lord, section 47.
Where is the written statement? Please give me the written statement. Where is this case made out in the written statement with regard to this number?
They say, my lord, that I am not in possession in any of the plots.
Yes. So 629 and 625.
Those are
they
the
are
Sabekdars.
disputing. 629 and 629 and 625. They have also made out their case on 629 and 615. LR Khotian number 42 and LR plot number such and such. So these are different Khotian.
Yes.
And 629 and 615, they're also referring to this. Where will be the difficulty?
No, no. My lord, now, my lord, the separate Khotian has been created in my name and the plot number has changed. This LR plot number 103.
How can there be two plot numbers?
Yes, my lord, that has what what they have exhibited, my lord. The witness someone has come and exhibited, my lord.
You are not disputing this.
No, my lord, that was marked exhibit. That was marked exhibit.
And you are accepting this.
For that, my lord, I have filed.
I'm asking you, are you accepting this record of rights?
Yes. Yes, my lord. As of today, yes.
So according to you, you will not be relying upon your record of rights which you have produced. You'll be relying upon this.
Yes, presently, my lord, the record of rights stands
That
in
is what I'm saying. You have said without giving you notice, this plot number has been changed.
Yes.
If that is so, then you are agreed by this.
Yes, my lord. That, my lord, I shall take proper steps before the appropriate
So please
forum, my
take
lord.
that steps.
my lord,
Thereafter, if
I
this
shall
is
say,
set
but
aside,
at present, my lord,
again there will be amendment.
no, my lord.
Then
Lord,
if
as
you
of
say
today,
you are not disputing this, I will consider, but I will record this.
plot number is only changing and Khotian number is changing, my lord.
Yes.
Otherwise, my lord,
So whether this is the same plot or the different plot, if you say yes, you accept your property has now been changed from that plot to that plot, you can do that. Because the measurement is also changing.
so measurement remains same, my lord.
How? It's 5 decimals.
It's around
In
3
plot,
chata.
plot number 1106. In 1106, how much you have claimed?
1106.
That was corresponding to which?
1106 is corresponding to 625 915, my lord. That is 3
Six.
chatas. 3 chatak. The quantum of the area remains the same, my lord.
How?
3 chataks, my lord, comes around 5 decimal only.
3 chataks comes to 5 decimals. How do you say, Mr. Kondol? How many decimals make 1 katha?
1.6, my lord. 1.6.
6, 5 or 6? 6. So then convert this into chataks. Quantum is also changing.
Lord, let that be incorporated. If I fail, my lord, my suit shall fail, my lord. The quantum gets changed, my lord, my suit will fail, my lord.
Quantum gets changed, your
My
suit
suit
will
will
fail.
fail.
The petitioner is aggrieved. The written statement also. Yes. Yes, 18.
For the opposite party, man.
18, my lord, I am for the petitioner, my lord.
I asking a copy, Lord.
Not a copy was, my lord, sought for, my lord. A copy was served, my lord. I just learned, my lord, without the annexures, my lord.
Without the annexures.
My lord.
So, Banerjee, what are you doing?
My lord, by this day, my lord, I'll serve a copy, my lord, with the, my lord,
Why
appropriate.
you want to? Yes, what is the order?
My lord, 3 orders have challenged, my lord. The first
What is the nature of the orders?
Yes, my lord. The first is an order, my lord. So, my lord, it's a dated order, my lord, 5th of February 2024, my lord, and the other 2 orders are, my lord, subsequent to that order, my lord. By that order, my lord, a psychologist was appointed by the learned trial court, my lord, to assess the psychology of a child, a minor child.
Who are you?
The mother.
With whom the child is?
Me. Child is with me, my lord.
What is the difficulty?
That is, my lord, the first order, my lord. My lord, I've got, my lord, documents, my lord, documents
So
are
what?
annexed here to, my lord, to show, my lord, that it is not necessary at all, my lord. My plea will, my lord, visitation, regular visitation is going on. It's, my lord, the second round of litigation, my lord. Initially, my lord, there's an observation by the special officer as well as, my lord, this honorable court as well, my lord, that child cycle, child is, the child
Is it
need
that
not be
matter which I once,
yes. Your Lordship, my lord, dealt with this, my lord, previously. At that point of time, my lord, there was a
round that was not interfered with.
at
151
that point, my
recall
lord,
rejected.
at-
Because of this
my lord, at
special
that
officer's
point,
report, my lord, I say the child is behaving so abnormally towards the father.
that
It's
point of
necessary-
time, my lord, there was a modification application pending, my lord. That was, my lord,
Banerjee, what is your difficulty? It's after all your child. If he needs some treatment, some
my lord, it has to, my lord, my lord,
Assess,
my lord, it has, my lord, it has to, my lord, come on the record, my lord, that a child, my lord, be subjected, my lord, to the, my lord, assessment, my lord. Your Lordship knows the consequences, what happens, my lord. My lord, socially what happens, my lord, if a child is, my lord, subjected to it, my lord.
This is
Your
lies,
Lordship, my
there
lord,
lies the problem. We always have these
my
things
lord, your
there on
Lordship,
our
act
mind.
minute. Your Lordship, my lord,
Something
your Lordship, my lord, knows, my lord, what happens, my lord. That's why, my lord, and my lord, there are, my lord, materials, my lord, to show, my lord, that that is not, but if it had been, my lord, the observation of the court, my lord, that is necessary, my lord.
psychological assessment.
Yes, nothing
That's
else.
necessary.
If it,
Mr. Banerjee, that's necessary.
if it was, my lord, the assessment of the learned court, my lord, that is necessary because of this abnormality, my lord, that would have been a separate issue. But there's no abnormality at all, my lord.
This is what you are saying.
Regular
Are you an
visitation,
expert?
my lord, regular visitation is going on, my lord.
Maybe.
There's an observation of this honorable court as well, my lord. By
Show me the order by which this direction was passed.
Yes, my lord, certainly. No, it's, my lord, 5th of February 2024, my lord. The certified copy is an annex, my lord.
5th
Page
of
1,
February
2024.
That's the first order.
That's the first order, my lord. Ei, eta ki paginate korecho?
Please show me the
Certified copy. Email আছে।
please
My lord,
show me
page
the
118, my lord, my lord, I apologize again, my lord. It's paginated, my lord. The certified
Page?
copy. Probably, my lord, the certified copy is paginated, my lord. Kindly see, my lord.
certificate copy is not paginated. Thank you. I must thank you. It has not been paginated. Yes.
My lord, it's also annexed, my lord, without the pagination, my lord. Page, my lord, the server copy is
Certificate
also
copy is
annexed.
not paginated. Yes. Which?
My lord, 5th of February order, 5/2/2024.
Yes. Internal page.
118.
Internal
Oh,
page, not
internal
running page.
Yes.
Internal page of that order.
Yes, my
What
lord.
is the
Lordship
page
kindly
number?
sees. Kindly, my lord, takes up the fourth page. Internal page 4. The order is, well, the specific order is that the petitioner father is at liberty to get the child.
Internal page 3 is the
Yes, I am at
reasoning.
3. I am at 3.
Your Lordship
Mr.
is looking at,
Banerjee,
my
it
lord, the
has to be
report of
done.
the commissioner, my lord.
No, yes, it has to be done.
The report of the commissioner, my lord, may I, my lord, may I? The report of the
Advocate
commissioner also
commissioner in
highlights
front of the advocate
that
Mr.
the
Banerjee, an
child
advocate
says-
commissioner was appointed. The school teacher's report is also there.
my lord, kindly see, my lord,
Sir,
my lord, may I,
why are you
my
shying
lord,
away?
may I? May I?
Why, don't you want the welfare of your child?
Certainly, certainly, my lord. My lord, there are, my lord, twofold aspects to this order, my lord. My lord, first of all, my lord,
It shows that you cannot protect your child.
my lord, first of all, my lord, at the behest of the father, my lord, the child is, my lord,
Not at
subject.
the behest of the
And
father.
secondly, my lord,
the court wants to know.
secondly, my lord, the learned,
Court wants
my lord,
to
the
know
secondly,
the,
my lord, the learned court directs the father to appoint the psychologist.
That has been clarified.
No,
Let
that is
that be
not, my
done
lord,
by
yet
an
to be, yet to be,
independent.
my lord, yet to be clarified, my lord, yet
No,
to be,
no,
my lord,
father will
taken
not
care of.
appoint. Father will not appoint.
Now, Calcutta University.
Tell me any government hospital, any university, any
This was the
psychologist,
last report. Kindly see.
any
This is not
psychologist,
blood by
May
me.
I, my lord, may I only
This
take
is
your
not by
lordship, my
any
lord, to the special
independent
officer's
person
report?
who, according to you, will be the best.
My lord, may I only, my lord, take.
Independent organization, not by me. যেটা ইউনিভার্সিটি অফ এতে তোমরা যাওনি বলেছে তারপরেও যাওনি This is the endeavor that was clarified.
Then the court should think of shifting the custody from the mother to the father.
My lord, kindly, my lord, may I? My lord, may I, my lord,
If you are,
my lord, let me, my
this
lord, place
shows-
the documents first, my lord, after that, your lordship, my
you
lord.
are acting against the interest of the child.
No, my lord, kindly, my lord, let's, my lord, take you, my lord, the
Who,
documents.
according to you, would be the best psychologist, child psychologist? Please suggest a name. I leave it to you.
My lord, may I only take your lordship, my lord, through the documents? After that, whatever falls from your lordship, my lord.
Independent. Your grievance was that appointed by the father. So you suggest a name. I'm giving you that liberty. I will not allow Mr. Mukherjee to oppose that. But an independent person. Suggest an institution, a reputed institution, child psychologist. Please suggest a name.
But I, my lord,
Last order, my lord,
personally,
the
my lord,
judge appointed the Calcutta University. It's not me.
my lord, personally, my
That's
lord,
why
I am
that
not, my lord,
clarifies.
familiar, my lord, with the name of psychologist, my lord. My lord, I'll take, my lord, necessary instruction. Only thing is, my lord, may I only place before your lordship the, my lord, the
Order
documents here,
dated
my lord.
5th of
After
May
that, whatever, my lord,
2026.
your lordship, my lord, falls from your
Yes, yes,
lordship.
5th of February, you are placing.
Fifth of May
My lord, fifth- my lord,
2026,
5th
the
of February,
court
my lord,
appointed.
my lord, initially, my lord, a revisional application was filed before this honorable court. My lord, whereas, whereby it was placed, my lord, that a modification application is pending, my lord, before the learned trial court, whereby I have prayed for a modification of, my lord, the ordering portion of that 5th of February order, and, my lord, tried to, my lord, appoint a psychologist neutrally. Now, my lord, this honorable court, my lord, appointed Mr. Rai, my lord, Mr. HON'BLE as, my lord, the special officer. My lord, kindly, my lord, takes up page 65 once.
65.
65 onwards, my lord, is the 66.
Rai, advocate of this court.
Yes, yes, Mr. Rai.
65.
65, my lord, I'll place, my lord, page number 66 and page number 70.
Yes.
66, my lord, kindly takes up paragraph number 5.
Yes.
That the child's behavior clearly suggests that he is deeply affected by the animosity between his parents. The unwillingness to meet his father appears to be a direct consequence of the toxic relationship between the parents. And unless and until the parents can cooperate with each other and work towards mending their relationship, the child's hostility towards his father is likely to continue. This is what, my lord, is reported by Mr. Rai. And, my lord, takes up only page 71. 70, my lord, the observation is, my lord, a bit, my lord, concerning. Page 70, my lord, first paragraph and second paragraph. The child complained to me that he is skeptical of meeting his father. As on previous occasion, his father was accompanied by police personnel when he came to visit the child, and as such, the incident left a very bitter mark on the child's conscience. The child also remarked that during previous visitations, an unknown lady accompanied his father to meet him and behaved badly with him, and that made him further mistrustful of his father, and he believes that the lady was coercing him on behalf of the father. Upon inquiry from the mother, I understood that the lady he is referring to was a special officer appointed by the court. As such, my lord, these are the observations of, my lord. আমাকে একটু বিস্মিত অর্ডারটা যেটা তো বলেছে দরকার নেই.
Yes.
And, my lord, kindly, my lord, takes, my lord, I'll just, my lord, may I, my lord, only place, my lord, এক copy আছে? My lord, may I, my lord, place, my lord, only the order, my lord, of this honorable court one. My lord, initially, my lord, this was taken by Justice Basu, my lord, at that point of time, my lord. My lord, kindly, my lord, takes up the 4th paragraph. Order, next order.
Yes.
And, my lord, one more order, my lord, may I place? ওই অর্ডারটা কত না পরের অর্ডার যেটা দিলাম পরেরটা যেটা দিলাম না এটা না parents need counseling.
Yes.
After that, my lord, the parties were directed, my lord, to go in for, my lord, a psychologist. They are, my lord, a psychologist, my lord, chamber. My lord, that
This revisional application has been disposed of by my lord. Thereafter, twice recalling.
That was, my lord, taken up by your lordship, my lord, subsequently. And, my lord, it was, my lord, disposed of at that point of time on the ground that my lord, the modification application is still pending.
And the modification is what? The mother wants that mutually we should appoint someone. Now, by the order impugned, last order impugned, the court has done that.
Where is your application for modification? So that has been disposed of by the last order.
No, my lord, modification
that has been dismissed.
Since, my lord, the 5th of February order, I challenged before your lordship, whereas it was submitted from the bar that the modification application of that order is still pending before the learned trial.
February modification was pending.
Now, my lord,
February, please show me the modification application and the order passed on that.
Order was not, my lord, kindly consider, my lord, that. My lord, the fact was.
Please show me the application first.
Yes. My lord, page number 72. Oh, no, no, my lord, this is the subsequent application. That is not, my lord. Copy is not annexed here to, my lord. 5th of February, my lord, application. I specifically, my lord, the modification application.
Where is the modification application?
That has not been, my lord, probably annexed, my lord. The only prayer was, my lord, that the psychologist appointed by the that was directed to be appointed by the father, let that be appointed by the court. That was the sum and substance of
That
that.
has been done.
That
That
has-
has been
that-
done now.
That was the, my lord, the sum and substance of that application.
Yes.
Now, my lord, it was submitted from the bar that that application was still pending. As such, your lordship did not interfere with the 5th of February order. Matter of fact was, my lord, that application was long gone. That was dismissed. My application was dismissed by the learned trial court, my lord. My lord, that order I have annexed.
Yes.
That order we have annexed.
Kindly, my lord, takes up once. Page 79. Judge have order.
79.
Please take me to the 5th of February you have shown. Then what are the subsequent orders which you are challenging? Let me understand the scope of this civil division application. Yes.
Yes, my lord.
Next. What is the
After 5th of February, my lord?
Yes.
28th of July order. 28th
Yes,
of July
28th
order,
of
my lord.
July, what happened?
My lord, kindly your lordship will find the order.
So this was for recalling of the order dated 5th of February.
Recalling of the order of the 5th of February.
Now what happened to this?
That was dismissed, my lord. May I take your lordship, my lord?
That was
the order.
disposed of.
এই তো আচ্ছা
Yes.
জন্মে হচ্ছে যে লাস্ট অর্ডারটা যেটা ডিসমিস করা জন্মে হচ্ছে যেটা আমাদের এগেইনস্টে লাস্ট অর্ডার 15 লাখ টাকা তো এই তো মার ওইটা খালি একটু বার করে রাখো
You are also against the visitation.
No, my lord. Visitation
The
is
written
going on.
objection you have taken that.
My lord, visitation, my lord. It has been, my
You
lord.
have taken that plea. Any forced visitation, compelled psychological assessment.
My lord, this honorable court, my lord, the module has been set out by this honorable court.
But
itself.
even in spite
That
of
is
that,
being, my
in
lord,
the
taken
written
up.
objection, you are taking this
My lord, visitation is being, my lord, going on regularly, my lord, by the module set out by this honorable court, my lord. My lord, this is the module, my lord. My lord, may I please? My lord, paragraph number 2, my lord, that the module has been set out.
Yes, now it's the court has appointed. Mr.
Yes, on my instance, they are all effort of recalling gone. Thereafter, I suggested by filing 151 application, let it be
What is
done
the
by the court.
difficulty?
Now, my lord, kindly considers, my lord, the third, my lord, impugned order. My lord, kindly takes up, my lord, 5th of May order. My lord, the last order, my lord, 5th of May.
5th of May.
5th of May. 5/5/2026.
Yes.
Yes, it's my application which has been considered.
My lord, their application, my lord, they have filed that since, my lord, the honorable court, my lord, I have, my lord, that order was never modified, 5th of February 2024 order, so it has to be carried out, it has to be, my lord, executed. This is, my lord, the sum and substance of this application. And, my lord, kindly sees, my lord, the order of this honorable, the learned trial court. Accordingly, my lord, may I please? My lord, 5th of May order to the order number 33. Accordingly, the application under section 151 dated such and such filed by the petitioner further is allowed in part. The OP mother shall escort the child Ondoti Mojumdar to the Department of Psychology, University of Calcutta for his psychological assessment and counseling as per schedule provided by the department. Regarding visitation of the parties shall follow the direction of the Honorable Court Calcutta as contained in order dated such and such. So that is one of that order I have handed out, your lordship, my lord. It is pertinent to mention that the petitioner approached this court with the instant petition since the petitioner and the OP, being guardians of the minor son Antodip Mojumdar, were unable to agree upon a question affecting his welfare. Since the court by the instant order settle the matter in differences between the parties in view of section 43(2) of the Guardians and was that any disobedience to the order will be viewed strictly and shall be dealt with in terms of 43(4) of this act. My lord,
And thereafter, I went to the psychologist, University of Calcutta. That's the last observation I have handed over before your lodge. From 2024 onwards, I am running Pillar 2 post, and he is saying visitation is happening. Visitation is happening, my lord, in a way that child is roaming around, my lord, in the entire, my lord, mall.
Mr. Banerjee, please hand over the child to the father.
my lord, kindly, my lord.
Let us see whether it improves after that psychological, whether it's necessary or not. I will consider.
My lord, kindly consider, my lord, one aspect, my lord, two aspects, my lord. My lord, specifically, my lord, it has been held, my lord, by this honorable court previously as well, my lord, as well.
Are you willing to comply with this order to go before the clinical psychologist? Yes or no? If not, you are acting against the interest of the child.
My lord, may I, my lord? My lord, may I come back, my lord, tomorrow with the instruction, my lord, specific instruction. Since, my lord, my client, my lord, challenged this order, my lord, with a certain things in our mind, my lord. My lord, may I come back
How
tomorrow?
many times you will challenge?
But this
An order has been passed,
my lord,
then recalling, then again.
my lord,
You are every day flouting the order of the court.
February order has been challenged, my lord, only once, my lord. My lord,
So this is going on. How long it will go on? And what's the difficulty to visit? This shows the more you oppose Mr. Banerjee, this shows there is something in it. Don't you want counseling of your child if it is necessary?
my lord, kindly considers the situation we live in, my lord. There's a my lord, I don't
Let
want,
the
my lord,
psychologist say so.
my lord,
You are not Mr. Banerjee, you are not an expert. Neither your client is an
my
expert.
lord, may I only say, my lord, what the erstwhile bench, my lord,
Are any of you
says, my
are
lord.
any of you the expert in this
No,
field?
certainly not, my lord, my lord.
You are not
We
the
cannot,
expert.
we cannot.
So the expert can say whether it is necessary. The expert may say yes, it's not necessary.
My lord, may I only quote, my lord, one thing, my
You
lord,
know
that
what
the
is
learned
there.
erstwhile bench, my lord, this honorable court, my lord, the erstwhile bench, my lord, my lord, prior to passing the order, my lord, what fell from his lordship then was there's a certain social stigma attached to, my lord,
I differ, Lord. I respectfully differ. It cannot be a stigma.
Social stigma. Have you seen the
school-going child,
doing
my
have you
lord,
seen
what's
the
doctor
latest
is a
medical
stigma.
reports on this?
school-going, my
And
lord,
your lordship's regulation
what,
that has been
what,
framed.
my lord,
Mr.
my colleagues
Banerjee, I am
and
telling you, I was while sitting in the division bench in a public interest litigation, we were dealing with a matter of this type. You do not know, it's not a stigma at all.
my lord, what,
You
my
are
lord,
thinking it of stigma.
my
It's
lord,
not a
what, my
stigma
lord,
at
might
all.
not be a stigma towards my colleagues, can be a stigma towards, my lord, the friends of a
Have to
9-year-old.
overcome. We have to
No.
overcome. Days have changed.
My lord, a friend of
Stigma
a
is what is playing in your mind
my
only.
lord, a friend of a 9-year-old, my lord, when it comes to know, my lord, when a school
Who will
going
know
child,
this? Who will know this?
when a school going child cannot be, my lord, stop talking, my lord. My lord, they will, my lord, say things, my lord, in school, my lord, their
It
friends
shows,
will,
Mr. Banerjee, don't want to take care of your child.
no, certainly
If
not, my lord,
if
that
there
is
is
not
some
the intent.
problem, let us think
My lord,
a child or a person, not a child, is suffering from some illness. Should he not go to the doctor for the treatment?
my lord, there has to be a
Whether
certain, my lord,
whether the person is an expert in that field or the doctor will say yes, treatment is necessary or not.
my lord, there has to be a certain observation that these are the abnormalities, that's why you need to go. My lord, in this case, my lord,
If you are on that, I can supply that from there. There are materials.
my lord, in
There
this,
are materials. If you are on that, if you are sticking to that, there are materials. I am telling you.
my lord,
I found that
my lord, kindly
there are
consider, my lord,
materials.
the incident
If
case
you
is
are
at the whims of the father. It's at the whims of the father, my lord. I'm being, my lord, my child is being subjected
My
to
child,
it.
yes.
My lord, the child is being
There
subjected
lies
to it
the
at the
problem.
whims of the father, my lord.
whose child is that?
Both of the parents' child, my lord.
There lies the
The
problem.
child is being subjected. But they are, but the
So
father
if
put
if
the show what materials are there.
if the father wants to get it examined, cannot be done. Father wants to know. So you are denying why? That means you are denying the right of a father, also of a child, not your husband. I'm talking about the father of a child. He also has some duty, some responsibility.
Certainly.
So if he wants to get an assessment, to know what his child is about, whether it is necessary, whether the father is not entitled to know that. Please stop the ego fight, Mr. Banerjee. Please stop. For the welfare of the child at least. You fight between yourselves. No difficulty on that. but don't use your child in a fight between both of you.
My lord, only my lord, let's make my lord come back tomorrow, my lord, with proper with my lord modified instructions, my lord.
Please don't fight. Both of you fight. Don't use the child in that fight. That's my request to both of you. And Mr. Mukherjee, you also take instructions. Unnecessarily should not be done. Only for satisfying your ego.
No,
Yes,
Lord,
it should be.
I shall.
After all, it's also your child.
Yes, yes, my lord. It's really things have happened, my lord, by this passage of 3 years, my lord. I shall demonstrate. I can demonstrate today also. My lord, I am, my lord, with these documents. Still.
And Mr. Banerjee, only one thing, if according to you instruction is that there is any other independent, better psychologist than that, that you can come with instructions, that can be also considered.
Grateful.
Yes.
19, my lord, I am for the petition, my lord.
Yes.
My lord, order 39, rule 4, my lord, pending since 2024, my lord. Well, they are my 2022 suit. They are, my lord, enjoying an order of, my lord, of 39-1-2, my lord, since then. My lord, 39-4, my lord, let this be disposed of, my
This
lord.
application under Article
Lord, item number 20, I appear on behalf of the petitioner's defendant. Suit for declaration and injunction.
What is the order under challenge?
My lord, may I place the entire fact before I place the order of challenge? My lord, what has happened?
Order under challenge.
The order is under challenge that a court, in spite of there being a limited remand in terms of order 41, rule 25, the court has travelled beyond the limited order of remand and allowed the amendment application, which
Where is the order of remand?
Order of remand is at page number, my lord. Page number 62, my lord, is the operative portion.
62.
62 is the operative portion, my lord. The instant suit is sent back to learned court below on remand for fresh trial with a direction that learned court below shall give opportunity to the plaintiff appellant for filing application under order 39 rule 7 CPC for identification of the pathway in question over which the plaintiff appellant wants to take electric connection, and he also shall give opportunity to file written objection against it and also allow them to adduce further evidence if any and pass judgment and
It's an
decree.
open remand.
My lord.
It's an open remand. Not a limited remand.
Only with respect to the identification of alternative pathway from which the plaintiff can take the electric connection, which is the case in the made out in the
trial afresh with that direction. It's not a restricted remand.
My lord,
it's an open remand.
Kindly take up
trial afresh.
Can
So
you
it's an
take up the
open
plaint?
remand.
My lord, can you take up the plaint?
It's not order 41 rule 25, Mr. What are you saying? Order 41 rule 25 is by retaining the file.
My lord,
it's not retaining the file.
My lord, kindly take up the plaint once.
It's not a remand under order 4125, Mr.
Well, only for the purpose of identification of the alternative pathway.
Sir, it's not. Please kindly come to order 4125. Whether it comes under order.
Claims an issue and send back.
Please see.
Yes, sir. Where the court from whose decree the appeal is preferred has omitted to frame or try any issue or determine any question of fact, my lord, which is in our case, which appears to the appellate court essential to the right decision of the suit upon the merit, the appellate court may, if necessary, frame issue and refer the same for trial to the court from whose decree the appeal is preferred, and in such case shall direct such court to take additional evidence required.
Please end.
My lord, and
there's something.
Such court shall proceed to try such issue and shall return the evidence to the appellate court together with its finding thereon and the reasons therefore within such time as may be fixed by the appellate court or extended by it from time to time.
So the appellate court retains the matter, only sends certain issues after framing them to the trial court to take evidence, to return findings on that, then again to send it back. That's not the direction.
My lord, what?
So this is not a remand under order 41 rule.
My lord,
25. Kindly come to order 41 rule 23A.
23A.
Yes.
23A is without except the preliminary point. If it is
otherwise then
preliminary point.
Yes, then.
My lord.
So it's a remand under order 41 rule 23.
My lord, kindly take up the plaint once. My lord,
that's a different thing altogether. So when it's you spoke about the scope, its scope is wide.
My lord,
it's an open remand under order 41 rule 23A. Now what is the order impugned which you are challenging?
My lord, order impugned is at
order 6 rule 17.
Yes.
Has been allowed.
Yes, they are seeking after the order of remand, they are seeking the declaration of the title over the 6 feet of passage over the land. Whereas the original suit relates to they are only seeking declaration that the defendant are creating disturbances in taking.
Where is the application for amendment?
Application for amendment, my lord, page number 80. My lord, 84. 84 and the schedule of amendment commences from 84. And 85 is the main portion, my lord. Para 2A before para 3 of this plaint, word a decree of declaration of 6 feet pathway from the house of the plaintiff.
Please show me the original plaint.
My lord, kindly take up the plaint as page number 34. And the prayer, my lord. Prayer is at page 36. A decree of declaration that attempt being taken by the defendants toward resisting the plaintiff or performer defendant from drawing electric line over the existing pathway for getting electric connection into the suit schedule property is illegal and bad in law. A decree of permanent
Nayak, learned advocate, appearing for the petition.
I am aggrieved by the learned trial court, being the 5th bench learned city civil court, accepting written statements of the defendants admittedly beyond the prescribed period without any condemnation being on record at the time when the written statement was filed or even thereafter. Lordship kindly takes the impugned order straight away. Impugned order is of 14th May 2026, Lordship. The last page of my application. Kindly seize Lordship. Defendant number 1 filed, Lordship has found it.
Please
Yes,
give me a minute.
yes,
Please give me 1-2 dates.
yes, Lordship.
When the defendant entered appearance,
Lordship,
when the summons was served,
summons was served by all modes on March 8, 2025.
March 8,
2025. Lordship,
when they filed the written statement,
Lordship, the defendant number 1 filed on 8th August 2025 without
August 2025.
Yes, Lordship, no application for condonation was
The
filed
defendant
along.
number 1 filed.
Yes, my lord. And there was no application for condonation and no explanation for the delay in the written
Only the
statement.
defendant number 1.
No, Lordship, 2 and 3 also.
Yes, 2.
Lordship,
When
2 and 3 simultaneously through different written statements on 11th December 2025.
both of them.
Yes, Lordship.
2 and 3.
2 and 3.
But different written statements.
Different written statements, Lordship.
Yes.
Defendant 4 has not entered appearance. Defendant 4 was set ex parte on 11th December 2025 itself.
Defendant number 4, you are not concerned.
No, also concerned, Lordship, because the impugned order directs fresh service upon the defendant 4.
So then service was not completed upon the
No,
defendant.
Lordship, completed learned court stood satisfied. Kindly takes page
All
25.
right, please give me a minute.
Yes, my lord.
The learned advocate appearing for the petitioner may be just.
Lord, I'm for the petitioner. This is an application for expeditious disposal of the plaintiff's suit, title suit of the year 2022, my lord. Now the suit is ready for hearing. There is one interlocutory application which is pending on my behalf. If your lordship kindly takes up the order dated 5th February 2025.
When did the defendants appear?
The defendants appeared on 7th August 2023. No, 22nd March 2023.
What is the petition dated 5th of February 2025?
Yes, my lord. It is a petition for complying with the order of implementation of the order of injunction which was passed on the previous date, my lord.
151.
151.
The regular presiding officer is there.
Yes, my lord. Regular presiding officer is there.
Charge court has passed the last order.
My lord, kindly takes up page 15 once. That is the last order which we have.
25th of March 2026 is the last order.
Yes, my lord. Thereafter, there is one more order which was passed on 4th June. That is in page 15, my lord.
15.
15, my lord. Here the presiding officer is there, my lord. The next date is fixed on 3rd August 2026, my lord. Again, the defendants had prayed for.
Why SR?
My lord, this is a wrong recording because there were 3 defendants. 2 defendants already filed written statement and the 3rd defendant was expunged. His name was already expunged. That is a wrong, inadvertent mistake.
This application. Pass over next.
This is application for the expeditious disposal. Herein I am the defendant of that. On 14th June 2024, I am appeared before the learned trial court and filed WSW and order 39 rule 4 on 5th September 2024. And thereafter order 39 rule 1 and 2 and order 39 rule 39 rule 4
Application under Article 2
pending.
This application.
In the said applications, I am the plaintiff of that petition, that application, and defendant appeared on 18th March 2025, and thereafter they have not filed any WS and W. Order 39 rule 1 is pending. 18th March 2025 they have appeared. Statutory limit beyond period is over. Till date, they have not filed the WS.
Under Article 227 of the Constitution.
Item number 26, I beg to appear on behalf of the petition. It is a expeditious disposal of the case.
Hearing of?
Hearing of a SARFAESI application under section 17(1).
SARFAESI application 17(1).
Yes.
So if it is not disposed of within a time, there's a provision in the, you can approach the DRT also.
The urgency, as there are 3 and 4 interlocutory application.
So you can move before the DRT. DRT also can pass a directions for expeditious hearing. Is there no provision in the DRT?
Yes, there is.
Then
my lord. But my
You
lord,
have to be on behalf of the opposite party bank in this matter. 17.6 is there in the DRT.
Then
yeah,
you can approach the DRT, sir.
yes, your
Then
yes.
Which one? No. The problem we are facing, my lord, each and every day, I am filing put up petition by paying.
DRT is there. You can file an application for expeditious hearing. That provision is also there.
That is,
If
but
there
that's
is
super. This
yes,
is my lord
yes, yes, for
227.
expeditious hearing, yes. There's a provision.
Section 19 is there. My
Yes,
lord,
I'm directing the SARFAESI to be disposed of.
I agree with you, Lord.
This application on
There are
Article
two
227
occasions.
of the Constitution. Other side.
Including the pending application. These are two applications are pending, which is very vital for my lord challenging the cell. Another is my lord possession order.
তাহলে এটাকে ঘুরিয়ে দিন the learned advocate যেখানে না petitioner submits that several interlocutory applications
My lord, I am for the petitioner plaintiff. My lord, I am petitioner praised for expeditious disposal of title suit.
what is the stage of the suit?
My lord, written statement and written objection has been filed by the defendant number 1, but SRAD for the defendant number 2.
SRAD is defendant number 2. How can this suit be expedited?
My lord,
this application
My lord, next date was 15/3/2027.
Madam, unless the suit is ready, it cannot be done. That is why I have said disposed of at this stage. I have not dismissed.
Grateful, lordship.
Pass over next.
Madam, may I please, Your Honor,
Yes.
This is not with regard to the preliminary issue. So far the pecuniary jurisdiction is concerned and also, my lord, so far the ad valorem stamp duty is concerned. My lord, the order passed on at pace.
Then come at 2 p.m.
As your lordship.
12 was passed over, my lord. Item number 12 was passed over, my lord.
28, my lord.
Yes. Pass over.
Under compelling circumstances, may I have your lordships kindly, my lord, this is a matter, my lord, where the judgment debtor has, my lord, has come up with an order in Rule 30. Now, that has been allowed ex parte, my lord. Now, my lord, there is an execution case pending with regard to a money suit. A money decree is there, my lord. Without any, my lord, condition, the execution has been stayed. My lord, tomorrow is the date for the, my lord, the order in Rule 13, my lord. If my lord kindly takes it up tomorrow, any time subject to your lordship's convenience.
It's appearing in the list.
No, my lord, it is not appearing in the list.
Where is it?
My lord, it is perhaps in the monthly list.
Mentioned tomorrow. Yes.
My lord, kindly takes it up.
Yes, it's called the list.
Madam, for the petitioners.
Yes.
I'm for the state, my lord. My lord, I'm praying for a short passover, my lord. Mr. Bhattacharya is engaged at court room number 8. I'm praying for a short passover, my
All right. When can he come?
lord. One half an hour, 1 hour, my lord. It's Appellate.
At 4?
My lord, I have some problem. My lord, Chief Secretary, my lord, I have a mediation center. I have to go mediation center, my lord. I have a matter.
Mediation center.
Then, my lord, can it be not today? Can be fixed by tomorrow?
Not today. Tomorrow. Not
That-
okay. Yes.
Lordship, I am for the petitioner.
7 yes.
Lordship, I am for the petitioner. Lordship, I have come up before your lordship with a very short and simple prayer. Lordship, my opportunity to file the reply to the questionnaire has been struck down because I was not present before the court on commission on call.
On?
When the matter was called. And I have stated the reason in paragraph 8 at page 8, Lordship, the Lordship comes to paragraph 8.
Where is what is the order impugned? Which date?
Lordship, 17th June 2025.
17th June 2025.
Order impugned, Lordship, at last page.
No, order impugned is 5th of February.
5th of
February.
5th of February. That number to 45 47. 47 partitioning.
Private
What do you say?
No power to recall.
Lordship, this is a procedural order. There is nothing for review or it doesn't come under the purview of review or record. It's a mere procedural order. Lordship.
Can a person be remediless?
No, he has filed his evidence. That day was the last chance. That day was last chance. He did not file his reply to the questionnaire.
Yes.
After 2 days, his chance to file reply was rejected. Now he filed an application though under section 40, but it will be 50. For a 50, there is no chance for this is a review. Section 50 is review.
May not be review, but can I
under the old act, under the old act, the Supreme Court has said no power to recall even.
Lordship, at page 64 is my reply, which is notarized on 10th of some days before the matter was fixed.
No, this is not review because there is no error apparent.
So there is no error. No other clause of recall. Only the National Commission has the power to recall ex parte orders. Under the old act, my lord, section 22 was there, 22A was, I have brought a judgment, but under old act. But under the new act, this section 50 has been there. So court has rightly held there is no power of review. There
are two distinctions. This is not a review.
My lord.
In a sense, it's not a review. That's right. The commission is right that there is no power of review.
And the commission has no power to recall its orders.
This is the state commission.
State commission.
It's the original proceedings before the state
Yes,
commission.
yes.
Lordship, it's a procedural order. It could have been reversed on the day itself. It could have been reversed by the learned commission on the day itself, Lordship. Because my item number was 4. I reached at item number 6, Lordship. Since there is no display board, I couldn't make up the 3 benches at a time. I have stated everything in paragraph number 8, Lordship. If your Lordship kindly comes to paragraph 8 at page.
Please give me a minute.
Lordship.
The line under 227, it can be done. 227.
My lord.
227, the High Court has the power.
Not 227 maintainable. But kindly see.
Maintainable, the court can pass directions.
Kindly now takes the position as per the old Act 86. Well, I have a judgment of the of a referral court, my lord. Kindly sees, I am referring to 2011 9 SCC. Kindly sees paragraph 8, 9, and 35. No, not 35, but 36. 8, 9, and 36. This is under the old Act. I have only one copy, but I have not got 8, 9, and 36. Under 8, there was a judgment which said that the State Commission and the District Forum has no power to recall or review. Then there is a divergence. 9, my lord, another judgment was there which said that no, it can recall or review. Now, this was again because this court was a referral court.
Which paragraphs you are referring to here?
8, 9. 8, 9 are the 2 cases, old cases, my lord. Kindly cases.
Nine says could review.
To review.
Or recall its ex parte.
Yes. Now kindly comes to 36, where the
paragraph 36.
Yes, where the referral bench
oh, this was on reference.
This was reference
because there was a divergence.
Says that judgment in 9 is 36 and
so Josna is the correct view. Josna says
no power to review, no power to recall.
Yes,
to get rid of the dichotomy of 86 Act, power of review was introduced in the 19 Act. No power to recall. This is basically an application to recall that earlier order.
Because there's a distinction between recall and review.
Yes.
Because technically, if an order has been passed on merits, disposed of or anything, you can prefer review. And the scope is there. So you have to come within that scope of the review to maintain a review. And it's also, unless the statute gives the right of power of review, it cannot be exercised.
Even
those
recall.
Those are well settled. Now the recall is...
Josna has clearly said that the statute does not provide any power to recall. This is a mere application for recalling of that order. Even if the 19th statute does not provide the power to recall, how this is maintainable? They have filed their evidence. They have filed their opposition. Everything is there. Only reply to the questionnaire.
Yes.
That part has been taken because he had given 2 chances. And there is no power to recall, my lord, under the statute. Rightly held, my lord. No review, no recall.
Whether 227 can be exercised in that. Yes, madam, what do you say to this? Don't nod your head. You have to give me something.
I have come up before your lordship since with an application under 227. Your lordship has the.
These are the judgments. What do you want to say with
Lordship,
this?
this is neither a review or a recall of. If a order is passed, final order, then
If the statute,
this is a procedural order, lordship. It could have been reversed on that
cite
day
any
itself, but
decision which says that even if the statute bars
Lordship,
this,
lordship,
227, it can be.
lordship.
Please,
Only to
please cite any decisions on that. Please cite any decisions on that.
lordship, I am not carrying today. But lordship, your lordship knows very well. Your lordship, in fact, lordship, if my reply is filed, it will enhance.
If you want some time, I can give you some time. Please do research for some.
It will enhance their argument position if I file my reply.
They don't want it to be enhanced. They don't want their case to be enhanced.
A simple opportunity will save my.
Madam, it's not that. The question is whether that order can be passed. You have to show me something. He's relying on a Supreme Court judgment on reference. Please consider this.
Then I have to come up with a. But lordship, the matter is fixed on 14th Tuesday.
14th of July.
14th of July, and the learned commission has specifically said either bring a stay order or do whatever. Otherwise, I will proceed.
13th is
This
the monthly list.
predicament.
My lord keeps it on the 14th. If they seek an adjournment there, we will not oppose.
The lordship learned commission will not allow.
Difficulty.
That is very. This is very.
By the order impugned, So what will happen whether under such circumstances, under Article 226 or 227, it can be done, even if the statute restricts the power. So please do some research work on that in those lines.
But this issue will crop up. This issue will crop up in this jurisdiction now. And lots of matters are like this.
Because, Mr. Lahiri, I tell you that that's the view. And you will get a division bench judgment, not one, several division bench judgments of our court on this. In some of the decisions, I am also a party in the division bench judgment. So this question, because in several statutes we will be finding, now what happens then? Maybe for certain reasons, though it's not recalling, it's condonation. In either way, the issue is if the statute do not give the authority to exercise power for certain purpose, so the authority cannot do that. Whether under 226, 227, that can be done. That's the issue which can be decided, because there's no dispute that the authority cannot exercise that power.
Josna, the Supreme Court has said it cannot do. Then I think 227 also is not. In Josna, I understand.
There are two things, Mr. Lahiri, there cannot be any wrong in that. That authority, you cannot say, yes, it had done a mistake. But the question is to grant relief, whether it's 226, 227, the court can do that.
But in this case,
because in those matters we'll be finding, so that's well settled. If the statute does not give them power to do that, under 226, 227, those delays have been
I would have raised the question of maintainability if it was a state forum, district forum. But district forum, all orders are appellable before state forum. But these orders of state forum are not appellable or revisable before the National Commission. So 227 is the jurisdiction.
No, 227, these are not revisable. Why?
No, before the National Commission.
Before the National Commission.
But it is therefore it is revisable before the Honorable Court.
Yes.
If it was a district forum, then all orders of district forum are appellable before the state forum.
Yes.
Only in cases of orders like this passed in state forum, no appeal lies before the national forum. Though 227.
No appeal lies, but the revision is there.
No, even revision is not there.
Revision before the National Commission is not there.
All are appeals now.
In view of the amendment.
To 19 Acts.
No, calling for the records is there, I think.
Previously it was there, now it is not there.
No
So
power of
227 lies. So I have not argued on maintenance.
No, that 227 lies. Even if there is a power of revision, there are judgments. It says that revision is not efficacious remedy because we have to travel to Delhi. So 227. So those line of decisions are here.
86 Act.
Yes, 86 Act. But here, if there is no power of revision, it will lie. So that's one part. Second part is
227 court.
Whether even if the statute do not empower that authority to do certain things, whether under 226, 227, that can be done. That's the issue. I can give you some lead. You can search out in Central Excise, VAT, GST matters. There will be finding the appellate authority do not have the power to condone. So under those,
Justice Sivagnanam. Pilot sitting with Justice Sivagnanam has passed up now.
There are other division benches also, because there are other division benches also. Those questions cropped up whether it can be done or not. So there it has been held that all right, you search. That I'm not giving you further. Yes. Next.
Madam, I am appearing for the prisoners' blood. I am appearing for the prisoners.
Yes.
Lord, our Section 10 application, Section 10 application for stay of the subsequent suit has been rejected.
Yes, subsequent suit.
Subsequent suit.
So you are the defendant in the subsequent suit.
Yes, sir.
You are the plaintiff in the prior suit. What is
I-
your suit for?
Our suit for declaration and injunction and the
What is the declaration you have sought for?
declaration of title, my lord.
Where is your plaint?
Page 14, my lord.
And what is the other suit?
Page 25, my lord.
Page
25, my lord. Title suit number 299 of 2025. Starting at page 25.
You have filed a written statement in this suit. In the subsequent suit, 2025
No,
suit,
written statement has not been filed.
you have not filed the
No.
written statement.
My
Now, what is the stage of the subsequent suit?
on the next date is on 23rd, my lord. Parties are same, property same,
Parties are same.
and the scheduled property in both the suits
Yes.
same.
You have sought for adverse possession against whom?
Suit for declaration and permanent injunction, my lord.
No, adverse possession, prayer 2, Roman II.
Jointly, my lord, against the defendant, my lord.
Against the defendants.
My lord, my lord.
So,
Are the joint owner, my lord. I have admitted that they are the joint owners.
yes. What are the issues? Issues are yet to be framed.
No, issue has not been framed.
Then how can you say that the issues are same of both the suits?
Issues, subject matter, scheduled property and parties are same, Lord.
Maybe. Issues may be different. If the issues are different, what does section 10 say? And if both are at the same stage, can be combined also. What is the difficulty?
Then, Lord, both the
Because it
suits,
says trial. Trial has not yet reached.
no,
Let the issues be framed.
then, Lord, both the suits may be hard, maybe tried, my lord, analogously, my lord.
After some argument.
of the subsequent suit, that is.
It is however made clear that pendants Yes.
The petitioner before lordship is a defendant of a suit filed by the plaintiff, my lord, for declaration, for my lord, cancellation and revocation of a gift deed. And my lord, but the prayer which
Cancellation and revocation of the gift deed.
gift deed, my lord, the prayer which has been made,
But the dependent of the plaintiff.
I'm the dependent.
Yes.
My lord, the prayer which has been made, my lord, is very in a sarcastic
What is
manner.
the impugned order?
Impugned order is at page, my lord, impugned order page
So by the impugned
35.
order, what has been done?
35. My lord, I filed one application for the hearing of a preliminary issue. So, but
Order 14 rule 2.
my lord, pecuniary jurisdiction and ad valorem court fee has not been paid. That is why, my lord. My lord, page 30 is my, lord, my application. My lord. Page 30. My
A
lord, though
suit
that
has been filed for revocation of a gift deed.
my lord, but the court fee has been paid.
Is the suit for revocation
My lord,
filed by the executant of the gift deed?
executant, my lord, executant, filed by the executant of the gift deed. My lord, kindly come to our plaint, my lord. May we permit to place it at page 14.
Yes, please give me a minute.
My lord, the prayer.
Give me a minute.
Sorry, I'm sorry.
Where is your application under order 14?
My lord, page, my lord, that is at page 30.
All right. Plaint is at page 14.
My lord, plaint is at page 14, 1-4.
Yes, please give me a minute.
And prayer portion is, my lord, at page 18. Relief which has been sought for, my lord, that is page 18. I've got 2 points. One is for, my lord, the ad valorem court fee has not been paid, and my lord, if it is not paid, and my lord, the so far the pecuniary jurisdiction is concerned, junior division civil judge is suit has been filed before the junior division civil judge. My prayer is to hear the 2 issues first, thereafter to proceed further. Whether at all the learned judge has jurisdiction to entertain the suit. Because ad valorem court fee has not been paid. Value of the property is not 10 lakhs as it is mentioned in the document.
There is substance in the argument of
Particularly order 7 rule 11 application has been allowed
allowed.
by the trial court.
Then
My lord, petitioner paper this revisional application and the main case, my lord, Act 8 case has been rejected. Order 6 rule 17 allowed, my case is
you said
Act
order
8.
7 rule 11.
Order 7 rule 11 is allowed, Act 8
Order 7 rule 11 allowed.
and my
There
case
is a
is
decree.
this is appellable order, but the Act 8 case number 03 or 2023 is dismissed or not maintainable.
Yes, it's an appellable order.
Appellable order. Man, your lordship, in revisional court, your lordship exercise is power for 220. So,
Yes, what do you want to do?
my lord, if your lordship asks me to take back the certificate, then prepare an appeal.
Yeah.
The expeditious disposal matter, I have challenged the order dated 12th May 2026. The matter is pending before the Learned Court Additional and District Judge Court at Howrah. Matter regarding a matrimonial suit. Matter is pending at case stage, my lord, issue frame. But from the date of filing,
The husband or the wife?
husband,
Any order for alimony?
issue frame, case stage issue frame. From the date of filing, the after passing of 2 years, the opposite party has appeared. After 2 years, they have filed written statement. Learned trial court gives so many times the opposite party. Delay the matter.
Application under Article 227 of yes. Yes, yes. Yes, what do you want?
This is for expeditious hearing. Suit filed only two quarters and something, land was purchased by, and some people is trying to occupy that land.
What is the next date fixed?
Huh?
What is the next date fixed?
'26.
It's application under Article 2.
My lord, I appear for the petitioner. This is my application for expeditious. I am the plaintiff petitioner, my lord. Suit of 2018, 2024. My witnesses' evidence has started. 2025 cross-examination. My lord, I am humbly praying that it may be made time-bound, my lord.
2nd of July 2026 for examination of PW1.
Cross-examination of PW1.
For cross-examination of PW1.
Yes,
You are the
my lord.
plaintiff.
Yes, I am for the plaintiff. It's my
How many witnesses you will adduce?
My lord, as of now, one, my lord. I don't
Only
think
one.
subject to instructions, my lord, one, my lord. My lord will make it a time-bound manner, my lord. We will also try to
Time, how can it be made a time bound unless you,
my lord will kindly,
till now you do not know how many witnesses you will adduce?
my lord will kindly keep me some within 3 months or 6 months, my lord. Let the suit
3
be.
months. Suit can be disposed of.
My lord, we will within 6 months, my lord, will kindly.
6 months
There is
without
only
any adjournment on the ground of
Any party.
resolution of the bar association.
My lord,
That you can assure. That's
That
in
I
your
can-
hand. That's in your hand.
My lord,
That
but
you can
either
assure.
party, as a plaintiff, we will take all that, that can be recorded, my lord.
This application under Article 227 of the
of injunction application which was filed in the year 2007. And it
for
is
the
pending.
plaintiff.
I am for the defendant number 4.
Defendant number 4.
It is pending. Plaintiff got
You
the
have filed any order 30 and rule 4? No.
next date 14th August. Next date 14th August.
14th
Nothing
of
happened.
August, it will be adjourned. No.
Oh, no.
14th of
No.
3rd of July, it was adjourned.
Yes, yes.
This application under Article 2. Yes.
I'm not the petitioner, my lord. I paper to computer. I'm for the petitioner. I'm tenant, lost the suit, lost in appeal, execution filed. In the miss case for police help, it is that matter, your lordship may recall that degree correction, Leela stores, Lali stores in last year. This continuation of that. The police help allowed, appeal filed. Now in that
self allowed,
police help allowed against me, I filed miscellaneous appeal where the landlord degree holders appeared and filed an application raising point of maintainability. Somehow the court allowed that application and held the miss appeal is not maintainable and directed to approach before the title appeal court, which I filed, but subsequently by filing a divisional application before a coordinate bench of this court, that order has been set aside, and again the miss appeal has been raised. Now, I am challenging an order by which occupational charges has been granted. My challenge to the said order over 3 points. First, the determination of the quantum of the occupational charge. Second, the date of implementation of the occupational charge. And thirdly, the court directed to pay occupational charge along with the contractual rent. These 3 points I am challenging before this court now. If you also very kindly look at
What is the area of your occupation? Extent of your occupation?
30 square feet, commercial shop room. 30 square commercial.
What is the nature of business you are carrying from there?
The materials of tailoring goods. Materials of tailoring goods. All these points are submitted before the court. Below.
What is the occupation charges directed to be paid?
8,000 per month.
What is the locality?
Locality is the Hinmotor beside the municipal road, which runs from the GT road from the station of Hin
What is
station.
the market rate of rent there of similar property?
2,000 to 2,500 most probably. But no.
Please vacate, go there, take a property, 2,500. It's better.
But no, it is.
Please go there, 2,500 you will be paying. Why we will pay 8,000? Please vacate, go there, pay 2,500, get a property. You can save.
I'm coming to it. The thing is that the other 10
It's not acceptable. This shows it's more than 8,000.
Very well.
This shows it's more than 8,000.
On instruction which I am instructed.
So your client instructed you their rent is
I asked my client what is the actual market rate in the locality in such kind of area of shop room. He says.
He said 2,500. Then you did not ask. Then why are you staying here? Please go there. That question you asked or you did not ask? I'm asking.
I'm coming to that part later on. But
no, have you asked or you have not asked?
Not asked.
I asked that question when I was on that side. From that experience, I am telling you. So if you get, please vacate.
Now, one thing can be done. I can ask my client if there is any time is required to vacate or not.
That's best. Please come on Tuesday. How much time?
14th. Tuesday 14th.
Unlucky day?
No.
15th, lucky day, or 16th, Rath Yatra, any day according to you,
After 15th,
your auspicious day.
After that week, my lord, after 15th or 16th, any day.
16th is an auspicious day for you.
You
can take that, choose that date. If you can find an alternative accommodation.
Any day, 17th or
But
any
file an undertaking and the consequences of that, you can ask from Mr. Chatterjee. He can help you on that. He is there.
My lord is always liberal. My lord is liberal.
That much he can assist you on that. I can tell you what happened. Yes, if he wants to leave sometime. How long you are proceeding with the execution case? How long?
My lord, the execution case is pending since 2013.
2013. So please wait for a week. Let us see what happens. After some argument, the learned
appear for the OP.
36, my lord, Mr. Bhattacharya is appearing.
Since I'm not inclined to take up this. Yes.
Plaintiff petitioner suit for recovery, eviction and recovery of possession on the under the TPA, Transfer of Property Act rather. Now, my lord, what happened?
But
I'm the plaintiff landlord. I have filed a suit for eviction.
Transfer of Property Act.
Transfer of property.
106.
106.
Or expiry of lease.
And non-payment of rent as well, non-payment of contractual rent. There was a leave and license agreement there was an arbitration clause in the legal license agreement, which was overlooked at the time of filing of the suit. I immediately filed an application for withdrawal of my suit, which is at, my lord will find that application at page 44, which was filed in December last year. On several occasions, that application was adjourned. After that, my lord, I invoked section 11 before this court and filed an arbitration proceeding for appointment of an arbitrator, incorporating the facts regarding pendency of my suit. Now, my lord, if my lord kindly comes to page.
What order you are challenging now?
No, I'm challenging, my lord kindly comes to page 53 for once, my lord. That is the order passed by this coordinate bench in regard to the section 11 proceeding. That A is posted on 14th of July. Now, immediately.
So that application has been adjourned.
Adjourned, fixed in October 5th. I have prayed for a shipback and fixed for that application to be taken up in an expedited manner. That has been turned down. That is the order improved before your lordship. I had filed that application for
You are
preponement.
responsible for that.
No, my lord.
You have taken a resolution on that date. You have taken an adjournment. Both
I-
cannot go hand in hand.
With regard to this, I've inquired, my lord. They have taken they have told me that you can give an undertaking that we'll do the matter on the date of resolution as well.
30th of April 2026, resolution of Bar Association. And on 22nd of January, adjourned on the prayer of the petitioner.
Yes, that is there because the
plaintiff.
evidence could not be adduced at that point in time.
So on all those dates, you have prayed for an adjournment.
No, the next 2 dates, my lord, kindly considers any date before 14, my lord, kindly directs the learned trial court to take up my application. I have prayed. That is rejected. That is before your lordship, my lord. I have prayed for shipback. Since that section 11 is season of the 11 code is season of that application of
I
appointment.
cannot prepone the date from here. That's the difference.
Grants me a liberty. I'll approach that court to consider that afresh, considering the pendency of the arbitration proceeding pending before this court. That much liberty be there, my lord.
No, my lord, plaintiff
Disposed of with the liberty বললাম না? CEO একদম দেখুন। CEO disposed of with the liberty.
plaintiff is the petitioner before my lord in a
What is
suit for
the plaintiff is the petitioner?
plaintiff is the
What is the suit?
suit for declaration of title and permanent injunction.
What is the impugned order?
The impugned order is, my lord, whereby, my lord, the petition filed by the defendant who was set ex parte was allowed. My lord, that show cause petition was allowed, and my lord, the order
Challenging that order.
yes. My lord, I'm challenging. Yes, my lord, your lordship. My lord, in this matter, my lord, the defendant number one, there are two defendants. Defendant number one appeared on 26th of April 2022. My lord, after kindly turns to page 31, my lord, that my lord will find from the order sheet.
You want enhancement of cost?
No. My lord, he could not have made this application. Kindly takes up the show cause petition then. My lord, what he has said in the show cause petition, kindly takes up the show cause petition at page 44 of the revisional application. Kindly takes up the third paragraph. That this learned court by its order dated 4th of March 2024 was pleased to fix ex parte hearing of the suit against defendant number 2, though no summons of the suit was served upon defendant number 2, either through court or through his. My lord, he is defendant number 1, not 2. Now, my lord, kindly turns the prayer, my lord, he is giving a show cause on behalf of defendant number 2, which is not permissible. My lord, he has filed wakalatnama for defendant number 1. Now, my lord, kindly turns on to the next petition, which is as page 46. Now, my lord, what the prayer for vacating? What are the dates? 4th, kindly turns to prayer directly, my lord. 4th of July 2023.
So this is the defendant number 2.
No, this is one who has filed the show cause petition. This is filed by, kindly sees the affidavit.
No, the suit is proceeding ex parte against whom?
Against both. Now both. But initially, defendant number 1 was set ex parte, my lord, on.
Defendant number 1 was set ex parte. When?
Yes, that's exactly, my lord. Defendant number 1 was set ex parte, my lord, kindly turns to page 33.
Date.
28 September 2022. By order.
Page
33. Sorry, 27 September, not 28.
27 September. Page 33.
33. What has got the first order of that page? The defendant number 1 files time petition to file WSWO. Statutory period is already over. Accordingly, time put petition is refused, and the suit fixed ex parte against defendant number 1. So, defendant number 1 was set ex parte on September.
How could it be done?
Malad?
How could it be done? How could it be done?
But he entered appearance on 26th of April 2022. Time was given to file WS. On all dates, he chose not to file.
WS is not filed ex parte. Where is the provision? Please show me.
My lord, the court has the power to set parties in ex parte if they do not choose to file WS.
Which provision?
Adjournment. Adjournment provision. After 3 adjournments, court will proceed. Adjournment, order of adjournment. What the court will do? Court will set them ex parte. Otherwise, there cannot be any ex parte.
What is the provision for setting a suit on ex parte?
The provision. Adjournment order.
Order 9 rule 6. Please
Order 9 rule 6.
Yes.
The page.
Yes. Please place that.
Where the plaintiff appears and the defendant does not appear when the suit is called on for hearing.
So how does it attract? He's present.
My lord is. Yes, he is present.
So if he is present, can it be put on ex parte? Mr. Chatterjee.
No, he cannot be.
Yes, from this order, it is to be set aside.
No, he cannot be put on ex parte, but
it has been put on ex parte.
His WS, my lord, he stands.
That's a different thing. It has been put on ex parte. That's the wrong order.
Now, my lord kindly appreciates. My lord, suppose my lord defendant doesn't file WS.
That's a different thing. It could not have been put on ex parte, Mr. Chatterjee.
My lord,
Could not have been put on ex parte.
ex
Order-
parte, my lord, here doesn't mean, my lord, in my in proceeding of a suit, my lord, suppose the defendant doesn't appear despite repeated opportunities given. My lord, he will be set at ex parte to the extent of he will be not be allowed to file WS.
That does,
Now, my
order
lord,
does not say so.
my lord, he is not
What-
barred from appearing in suit and, my lord, putting me in cross-examination. My lord, that court has not debarring him.
Saying he is all along present.
No, my lord, that's why he can participate in the suit, but he cannot
How?
file WS.
How? Where
My
it
lord,
has been clarified?
his show cause is,
Where it has been clarified.
my lord, his show cause itself is clarified. It is understood by all parties.
Next provision, Order 9 Rule 7.
Yes. Procedure where defendant appears on the day adjourned hearing and assigns good cause for previous non-appearance. Yes. So, my lord, kindly, that's why I take your lordship.
Then proceed. Don't stop there.
Where the court has adjourned the hearing of the suit ex parte and the defendant at or before such hearing appears and assigns good cause for his previous non-appearance, he may, upon such terms as the court directs as to cost or otherwise, be heard in answer to the suit as if he had appeared on the day fixed for his appearance. Yes. So, my lord, he has to show a cause. Exactly, my lord, I am not. Kindly takes up the show cause. And my lord, kindly takes up the impugned order. My lord, kindly takes up the show cause.
27th of September order is wrong.
My lord,
That is
if-
set aside, everything.
then, my
goes.
lord, the court has to say it my lord, in my little bit of experience, when a party doesn't file WS.
Promoter park also can be exercised under 227, Mr. Chatterjee. This
Yes.
order is palpably bad on the face of the record.
My lord, similarly, my lord, kindly takes up
I mean,
the impugned order.
or under
Kindly takes up the impugned order, my lord.
Prior to that, if this is set aside, everything goes.
Now, my lord, what he is praying, my lord, he is seeking and my lord, recall of an order in respect of defendant number 2.
Need not have if it is set aside. Mr. Chatterjee, this is
My lord, kindly sees the conduct. My lord, whatever is there, my lord, I will place on conduct.
Conduct is a different thing.
That's exactly, my lord.
Present. Could not have been directed to proceed ex parte against him. What are you saying?
My lord, my lord, my order is, my lord, then trial court ought to have recorded, he will not be allowed to file written statement. My lord, this order doesn't come up, parties are set ex parte.
That's a different
My lord,
thing.
that's a, my lord, usual order which is passed.
I can only go what is recorded in the order.
My lord, that's exactly meaning, my lord, kindly do not lead one line of ex parte.
Yes.
But why he said ex parte, that's kindly reads, he is not allowed to file the WS.
Mr. Chatterjee, what does it say? If a person does not file written statement, it will be put on ex
My
parte.
lord, this
Even if he is
my lord,
present.
subject to correction, my lord, we have what I have, my lord, understood, my lord, subject to correction. My lord, when a party is, there are two kinds of ex parte. One, my lord, a party who doesn't appear in the suit for all along. A decree is passed ex parte finally against him. One is, my lord, when he appears, but doesn't turn up in hearing. My lord, this is another set of ex parte. So, my lord, this is a case where, my lord,
Put this case under which ex parte
my lord,
category?
I tell your lordship, my lord, he appears, but he just doesn't choose to file written statement and contest.
Yes. Then
So, my lord, in that
can
situation,
cross-examine you.
he can cross-examine me. My lord, I have no
On
difficulty
the
in that.
decretal part, what will be recorded? Contested or ex parte? Please tell me.
My lord, in the decretal part, it will be recorded, the defendant appeared but chose not to file written statement.
In the decretal part, suit is decreed on contest, suit is decreed ex parte. What should be recorded?
My lord, it should be recorded, my lord, there should be a recording that he chose not to file WS. To that extent, that should be recorded in decree.
No, I'm asking you contested or this should be a contested degree or an ex parte degree?
My lord, this would be, in my humble submission, a contested degree where there is no WS on record.
Contested degree.
But there is no WS on
Ex
record.
parte. There lies the problem.
My lord, that's why I say, my lord, that's why I say,
That is the
my lord,
problem, Mr.
do not take words by words of the order, but my lord, from the show cause and from the order itself, it is apparent, my lord, to what extent he is being set ex parte. My lord, it's not that court is not allowing him to participate in proceeding. That is not his show cause also, because he is appearing all day.
What is the suit for?
My lord, suit for declaration of my title.
Meritless suit, Mr. Chatterjee.
Absolutely, my lord, this is frivolous suit on their part. They are contesting just to harass me. My lord, their predecessor, I tell your lordship, their predecessor has already filed suit against me.
You want to expedite your suit or you want to delay your suit?
My lord, I want, my lord, this conduct should not be go in this manner. Just because a wrong recording or wrong line. My lord, the meaning is very much apparent on it. Why he is being set ex parte. His show cause is apparent. He wants to file a WS. So, my lord, if this is allowed today, my lord, then anybody can deal with court in any manner they want. So, my lord, this cannot be allowed. My lord, this is my respectful humble submission, my lord, and if I take my lord to the written statement and my plaint, which they have filed on today, but my lord will find they themselves says their predecessors and my plaint case also, Their predecessors has also filed a suit which they have lost. My title has been declared in one suit. Now a third generation comes in.
Get a contested degree, Mr. Chatterjee.
Well, kindly cease the conduct, not in this manner.
Contested matter, it appears, Mr. Chatterjee. Because all to at what stage ex parte, not ex parte, what is the meaning of the expression good cause and sufficient cause under Order 9 Rule 13, good cause under Order 9 Rule 7. So you have to make arguments on that. So it is on a higher pedestal or what things.
I will only one thing.
Also take note of some
Malad
of the
has,
decisions.
made it returnable on Milord.
Contested applications after 6 weeks.
After 6 weeks. Sure.
Only disposal of the partition suit, Milord, the WSN filed in 23. Milord, since then, Milord, it is adjourned, Milord, for.
What is the
decision
stage
or
now?
otherwise. No, what stage is, Milord, WS is complete. Milord, now the issue is to frame and Milord, the proceedings. Milord, so what I am trying,
This
you are
application under
logically
Article
direct.
226.
My lord, this is the application for expeditious disposal of the title appeal. My lord, I am the decree holder. Petitioner.
But the
here is-
respondent in the title appeal.
Yes, ma'am.
This application under Article 227 of the Constitution of
opposite party number 2 in the proceedings, but before the estate officer. Now, what happened? In kindly turn to page 25. A notice has been, a possession certificate has been issued in favor of the opposite party number 1 by the Shama Prasad Trust. Now, my your lordship will find in detail page 25. Kindly see that the possession.
You are challenging.
I'm challenging. My kindly, unless your lordship has gone into two document, my lord, I can't explain your lordship. Now, my lord, admittedly, my lord, proceeding has been initiated against the opposite party number 1. Now, my lord, I am nowhere connected. Now, my lord, no demand.
But the opposite party number
2. Opposite party
What's
number.
the relation between 1 and 2?
No, nothing. Nothing. Now, what happened, my lord? The demand has been made against opposite party number 1. Port Trust has not made me party. This has been done by the OP number 1, not by the Port Trust, Shama Prasad Trust. Now, what happened, my lord? Your lordship will find all that demands is against the opposite party number 1. I am nowhere connected. Now, my lord, I received the summons. Now, my lord, I said that I am not in possession. Where I am in possession is not the Port Trusted land. I filed an application for local inspection. Now, my lord, that has been turned down by one line order. I came up before this court. Now, this honorable court, the coordinate bench, my lord, after considering, my lord, the entire aspect and found that you are no way affected because you are not at all required a party. Because, my lord, what happened? No demand has been made against me. Now, my lord, court opined that I can file an application for expunge of my name. I filed an application. Court said, as I have not filed the, my lord, so-called reply to the so-cause, although initial proceeding was not against me, my lord, what happened? Suit has been argument closed. It is fixed for delivery of judgment.
How will you affect it? You are not a party. Let a judgment be passed.
But kindly visualize.
You are not in possession. There is no due.
Absolutely, I am in possession in respect of my position. That is not. Kindly see once, my lord, the demand. Kindly see once.
Yes.
My kindly see once. All the demands your lordship will find. Kindly turn to page.
You are appearing for the Port Trust.
No, I am appealing for the. I believe the opposite party number 2 has been impleted. Who is the opposite party number 1?
He is
Fight between both of you.
No, I don't know him.
And Mr. Nag is laughing from behind.
I am not doing
it.
Both of you are fighting. Mr. Nag is.
Mr. Nag is higher than সবার উপরে এখন
Can you accept the
No.
It cannot be done.
No, I am not. And we are serving.
Let him take instructions. The instructions has to come.
Kindly keep it after 20th only.
After Tuesday?
After 28th. Because 15 to 17 I will not be here.
15 to 17th he will not be there. Where will he go? 14th.
ওটা না হলে দেওয়া হচ্ছে
Yes, difficulty.
No, from 14, দাদার বিয়ে নিমন্ত্রণ করবে তো
This is
order by this time. No, otherwise if they pass this order by this time, this revision became infructuous.
Spending.
No, from interim order, my lord, a civil revision does not lie.
Yes,
I will
yes.
satisfy
Call the
you,
next
lordship.
matter.
If this is the kindly, but it is understood, my lord, they will not pass the order after this day.
Understanding, don't make quota party, understanding between all of you. Don't make quota party in that understanding.
ওনার নাম জানেন না
is directed to serve a copy of this application upon the opposite party and file an affidavit of service on the next date. Full stop. Considering the fact that the petitioner has prayed for enhancement of alimony, which was rejected by the by an order dated.
No, the first enhancement was allowed considering the only submission of
No,
65,000.
August 2025, what was done?
But that was, my lord, I have filed an application asking him to bring the earlier payments. I am not issuing on that issue, my lord. It was the earlier payments. Kindly consider 2024 while the court disposing the application only on the oral submission that husband is earning 65,000.
The 2024 order, now you are challenging.
That RTI was not available to us immediately when the RTI came to our hand. We filed the application.
The petitioner has challenged the orders dated 13/3/2024, 30th of August 2024 and 24/6/2026, passed by the learned Additional District Judge, Third Court at Alipur in Matrimonial suit number 1 of 2013. Why? Mr. Bordon said he will be taking only 5 minutes.
Lord, I have instructions to appear on behalf of the bank.
Yes.
And I personally feel that, Lord, instead of calling the advocate and, Lord, trying to ascertain, Lord, what really happened, Lord, the best course open is that, Lord, there has been a fresh notice under 13(2) issued by the bank. And, Lord, that is challenged, Lord, by my learned friend under section 70. That in that challenge, he has also challenged, Lord, the issue of declaring the account as NPA. So, Lord, kindly keep the point open, ask the tribunal to decide the matter.
But what will happen to the earlier order passed?
Earlier order, Lord, is the review order. Earlier order is on review. He had filed a review.
The entire thing, the second 13(2) is after the first round of litigation.
And he has succeeded. After he has succeeded, the original notice was set aside.
Succeeded on one point, but not on the other point.
Lord, the question of NPA, if your lordship keeps it open, his application under challenging 13(2) notice is pending before the tribunal.
Mr. Bordon, what do you say?
Lord, kindly takes up.
That's a very fair suggestion.
Fair suggestion. But what happens is, Millard, tomorrow they will take possession. Tomorrow they will take possession. So if they can hold it back for some time and let the let that.
Tomorrow they will take possession pursuant to what?
That is because
DM's order.
That is because, Lord, his interim order of staying the DM's order has been refused
Millard,
by the tribunal.
For the new.
Page 138.
Under the new proceedings,
Page 138.
he has challenged.
What ground?
Kindly seize 138.
138.
138 or 146?
146, the interim order. Refuse.
My lord, kindly take the 144 and 146. Kindly take the page 144. Relevant portion will be page 145.
145.
My lord, the third last paragraph. Since appellant has.
Yes. Preferred a review of the judgment. That's the earlier one.
Now, my lord, the next order.
So, Mr. Bordon, please clarify this. SA 293 of 2025 is from the second 32.
Yes.
Now, so from here, since you have preferred a review of that.
No interim order can be passed.
Mr. Kaur, what,
That
because.
is one. My lord, if that is not enough, comes to the next order, page 146. Kindly seize. We have said everything. NPA everything. Kindly seize the second last paragraph at page 146. We had submitted the issue of NPA was not decided. Seize my submission, Mullah. Then, Mullah, kindly seize. Learned counsel for respondent on the contrary submits such and such. Section 11 CPC bar. So specific point. Then, Mullah, kindly seize the next page. Page 148. The top paragraph. Learned counsel for respondent bank argued that when the tribunal did not pass any order regarding NPA, the same has to be construed as refused by tribunal. Then, my lord.
Same issue cannot be raised.
But that is the reason why I was saying that if your lordship clarifies, Lord, the point is that the bank had requested the learned advocate to appear. He has not.
You cannot have a hold on that.
We don't have a hold. And your lordship said that to request the learned advocate to come. Lord, he has not come. I thought I would try and, Lord, put across a suggestion which will, Lord.
No, that's only one thing. Mr. Kaur, if you want to go through this matter, I can give you time because please go through these orders because we'll be making some submissions because he is very well prepared on
No,
this.
of course.
Because,
And I'm not
I think
prepared
today
at
is
all
the
because
first, third day
I
which
was
is
just given
yes.
the brief half an hour back.
So
and
that
I'm
is why only one thing since today is tomorrow is the date fixed for possession. Please
No possession.
No possession. I'm telling you.
Last 6 months they're making this.
let us not
Police
go into
station,
that.
Malibanjpura Thana is
6 months they're saying this.
I'm keeping it on. Please don't take any steps. I'm keeping it in the next week. Please you go through this matter.
Especially fixed matter.
Kindly will not fix a time
because there are some things, some observations here.
I tell your lordship, if your lordship goes through, Lord, the merits of the matter, it is always the court records which is, Lord, to be taken to be true. There can't be, Lord, any two opinion about it.
Mr.
Because
there.
Lord, I saw that request that your lordship had made. That's why, Lord, I asked the bank to make a special endeavor. Now, Lord, I am told that
because only thing, Mr. Kaur, at times it happens. Let us assume that both of you are appearing in one matter. Now, something has been recorded in the order. Yes, records are sacrosanct. What is there? What is recorded here? Now he comes up and says, "I have raised this point. Your lordship has not recorded."
There is a procedure.
But yes, there's a procedure, and it might have also gone through my mind. Yes, but you are there. At times, you can also say yes, yes, my lord. So
absolutely
only for that, to see that the learned advocate who was present, it might be at some times the judge who was deciding, it may have gone out of that one because that is why that decision says you have to approach that court when it is still fresh in the minds of the learned judge. That's the exact expression which has been used.
For correction.
For correction.
Yes.
So it's so that it is fresh in the minds. So it must have at some point of time it must have gone out of the mind of the judge also. For that the party should not suffer. And instead of that, it's a fair suggestion which you have given. But please go through this because he is saying because he has to be protected on those res judicata and other things. Those are to be, and what would be the effect of those? Please consider that.
Lord, kindly come to page 148. I'll definitely will look into that.
Yes,
kindly will come to page 148.
Yes.
I don't think, Lord, it was only on res judicata.
Kindly seize it. There's no finding worth the name. Kindly seize the order.
Kindly see page
148. Kindly seize the order.
Kindly see page 148. Lord, may I just read page 148 once?
Yes.
Kindly come to, my lord, the second paragraph at page 148. The
Yes.
learned counsel for respondent bank argued that when the tribunal did not pass any order regarding NPA, the same has to be construed. Then so far as direction of the tribunal is concerned, respondent bank has complied with by annexing statement regarding the interest due. Magistrate has passed an order on the basis of 2 affidavit, 9 points affidavit, another affidavit, whether any stay has been granted or not. Learned counsel for the respondent bank has also relied upon judgment of the Honorable Court, Joldhaka, etc., heard both sides. Then let the respondent bank file objection. At this stage, there is no ground for an interim order in view of reasons given. It
Where
is
is the
not
reason?
made-
All the reasons. One of the reasons is that it's res judicata.
What I wanted to show is that the court, the tribunal also considered his prima facie case. That's why, my lord, Joldhaka was taken note of, and they then said that there is no ground for passing interim order.
That 9-point affidavit, one of the point is with regard to NPA.
Bow down.
That's true.
So one of the point is with regard to NPA. So this also touches upon that.
No,
This also
Kindly-
in a
kindly give-
indirect way touches upon that.
Kindly give me 1 minute. I don't think, Lord, NPA is one of the points. Subject to correction.
What are the information that you need to give in an affidavit?
Just
to
just
the
a
এই
magistrate?
দেখি,
These are the lines.
SARFAESI Act এ।
Aggregate amount.
I think one of the
Yes.
one of the clauses refers to that NPA.
Classification of NPA.
I think classification of NPA is not one of the
No,
points.
not the
That's
classification.
the account of the borrower as classified as NPA.
Yes.
So
Now
kindly see,
he's challenging that.
kindly see, Lord. Kindly see the conditions.
Yes.
This is after amendment, Lord, 14(1)(b) has been incorporated.
Yes.
The aggregate amount of financial assistance granted to the total claim of the bank as on the date of filing the application. Borrower has created security interest. Then borrower has created security interest over various properties. Borrower has committed
Five.
default. Consequent upon such default in repayment of
Yes.
the account.
Classified as a non-performing asset.
Yes.
And according to him, that guidelines has not been followed with regard to this classification. That's one of the challenge.
Lord, this is not a declaration. Your lordship is right, which is required to be given. But Lord, point today is very on a limited campus. The limited campus is that Lord he wants. Lord, then Lord, let him pay some money. If your lordship is
one
going to
thing,
give him that relief,
because-
let him deposit the money.
because,
The fact that
What is troubling me is that if he had succeeded on the NPA issue in the first round, then this could not have come.
Lord, if your
Because the
lordship,
NPA, if he succeed, then NPA would have gone.
And that was the
Then there
ground in
would
my
not have been
objection to 13.2.
Lord,
So please go through this. I'm
NPA,
keeping it in the
Lord,
next week.
going away of NPM, Lord, does not change the situation. Has he paid any money?
I don't need to, my lord.
Let us, Lord, stick to this, that up to a period, if no money is paid, the account can be declared as NPA. This, if your lordship wants to test this, Lord, I can come ready on this.
On
Kindly
NPA,
test it. Kindly
ready,
test
my lord,
it, because
NPA, my lord.
Lord, this is the point which he is trying to urge. Kindly consider this.
Mr. Kaur, that's a different thing. Without this, because that is the issue touching upon the advocate. We have said, I can, making that clear, I can delegate.
33 crores is due,
And he's
Lord,
saying he
on
doesn't
this
need to
account.
pay.
NPA, no NPA, let us forget about this. Lord,
We cannot forget
after all,
about
this
this,
is
my lord.
public money. We cannot, Lord, hold ourselves for eternity. There has
Sir,
to be,
Bordon, maybe you can deny the quantum.
No, my lord,
But are you denying
my lord,
that?
my lord, may I put this, my lord, may I put this way, my lord. The bank is not a kabliwala. I'll be, my lord, let me voice my opinion
According
today.
to you, nothing is due from you.
May I say this, my lord? My lord, kindly visualize. It's only after a proper classification of my account as an NPA, a 13(2) demand can be raised.
Mr.
My lord,
Mr. Bordon, that's
Lord, what happens? Well, kindly bear with me, my lord. What happens? Once the issue of NPA and the bank classifies my account as an NPA, my lord, I am starved of all finances. So the question of me running my business to repay the bank doesn't arise. The RBI guidelines mandate that in the event that even if an account is declared as an NPA, my lord, I can regularize the account. But the point is, if I am starved of, my lord, the funds, my lord, there's no question or no opportunity granted to me, my lord, to regularize my account. There's the problem.
so you
according-
starve the bank.
According to you, how much is due?
My lord,
Forget about the bank.
my lord, I say nothing is due because my account has been classified as an NPA illegally.
That's Mr. Bordon.
My lord, it might be difficult to digest, my lord. I am aware of this, my lord. It might be
So-
difficult to digest,
Yes.
but my lord,
So, leaving aside their claim, I am asking you how much
Lord, may I-
according to you is due.
my lord, may I say this, my lord? if my account has been wrongly classified as an NPA on a particular date, my lord, since that day, my lord, I'm starved of finances. So, my lord, the issue today is whether the account was properly classified as NPA on the day. If it is properly
Bardhan, I'm not on the point of law that I will decide on a subsequent.
Lord, I appreciate that.
So I'm asking you.
But that I have to take instructions. I'll have to take instructions. Because, my
please
lord,
take instructions whether according to you, what is,
my lord,
according to you, the admitted dues.
my lord,
Forget about his claim.
my lord,
And this
my
is
lord, may I put it
applicable
this way?
order also.
My lord, may I put it, my lord, may I put this in this way, my lord? May I put this in this way, my lord? My lord, suppose I was supposed to pay the bank the monthly EMI as on a particular date. Now the bank declares my account as NPA.
All right, Mr. Bardhan, you take instructions, come back. I'm
My
keeping
lord,
it.
what even I was suggesting is subject to what eventually falls from, my lord.
Yes.
Let us go back to the DRT. Remands it.
Let Mr. Bardhan, you are saying that
I appreciate.
that observations which has to be without going, let Mr. Kaur go through that.
I appreciate.
Because what is the implication? After all, he is also representing an authority.
I stand. I stand. I stand.
You might have appeared before the tribunal, and this is the third day you are appearing.
I stand
Mr.
corrected.
Kaur has said that he has been briefed only half an hour before.
I stand corrected. I retract, my lord. I retract that. Sorry, sir.
Yes. Who will start first?
It is a list of date.
My lord,
Correction, correction.
my
List
lord,
of date.
I shall only, my lord, distinguish the judgment cited by Mr. Ghosh. 84 Calcutta and, my lord, the Bombay judgment which Mr. Ghosh has cited.
This is the list of dates.
Yes. I have annexed all the orders. A copy আছে list of dates.
So all the orders were not necessary. I only asked you to prepare a list of dates.
Because, my lord, the how the execution proceeded, that is the reflecting the orders.
No, no,
Yes.
Or whip.
Yes.
I have the pen drive with me, my lord, where I have
That soft copy.
soft copy.
একটুখানি download করে একটা copy.
ওই এইটার just a
Copy
soft
একটা
copy
একটু
চেয়েছি।
তুলে রাখতে বলুন।
Oh.
List of dates.
List of date. It is not.
Yes.
No, my lord, facts I am not going because, my lord, it has been narrated.
Only issue here is whether during the pendency of section 5 application,
The execution should be stayed or not.
yes, the appellate court
As power.
pass an order of stay.
Yes.
That's the only issue.
That's the only. That's
The facts are there.
Yes, yes, yes.
First is the legal issue,
Yes.
then facts.
Yes.
On the facts, what it stands, then it is to be
Now, my
considered.
lord, Mr. Ghosh has cited before your lordships the decision of this honorable court, EIR 1984, Calcutta, page 20. The division bench judgment of Justice Asham Kulpar and PC Bodua.
80, yes, for Calcutta. Yes.
দিয়ে দে গোপাল দাগাটা দিয়ে দে।
Yes.
Now, my lord, in this decision, my lord, what has been challenged is an interlocutory order. Interlocutory order and appeal was preferred, and in that appeal, the stay was not granted. Then, my lord, it is held by this honorable court that during the pendency of the proceedings, the stay can be granted. Now, my lord, kindly come to, I am not troubling you lordship because the entire. Now, my lord, kindly come to, my lord, paragraph 8.
Yes.
Mr.
Yes.
Mr. Gupta argues that Order 41, Rule 5 does not operate as a bar to an ex parte order of stay. He has also drawn our attention to the words so far as may be in Order 43, Rule 2 of CPC. His contention is that in case of an appeal, especially from an order, there cannot be, I am emphasis on that. His contention is that in case of an appeal, especially from an order, there cannot be an absolute bar for applicant to ask for a stay before condonation of delay is granted, as the provision is still there for the appellate court for ordering stay of execution on sufficient cause. Mr. Gupta has also drawn our attention that the opposite parties have not filed any affidavit in answer to their petition. So far as the application for condonation of delay is concerned, he submits that the notice has been served on the parties and the matter is ready for hearing. Mr. Gupta asserts that for the ends of justice, the stay as spread for should be granted and the application for condonation of delay may be heard as early as possible. Otherwise, the entire application would be rendered nugatory. Paragraph 9. The provisions of Order 41, Rule 3A provide that the court shall not make an order of for stay in execution of a decree against which an appeal is proposed to be filed. It may be noted that the decree determines the rights of the parties with regard to all or any of the matters in controversy in the suit. Order is the formal expression of any decision of a civil suit. Therefore,
the incidence or legal consequence of a decree fundamentally differ from those of an order, that must be one of the reasons why in order 43 the words so far as maybe have been incorporated. So in the case of an order that is interlocutory in nature, that can be stayed for an interim period if the justice of the case so demands, so provided an application for condonation of delay is there. It may be noted further that Order 43 Rule 2 of the CPC relates to procedural matters, and matters relating to grant or refusal of stay cannot be said to be procedural matters by any sense of the term. Moreover, the full bench decision referred to above is not applicable to this case. In that case, the application under Section 5 of the Limitation Act was rejected. In the present case, it is pending. Mr. Gupta has cited a judgment in 78 Calcutta was cited. It was noted. Now kindly come to paragraph 13. We concur with the observation made by Justice Nag referred to above, irrespective of the provisions of Section 1 of this Section 151 of the CPC. We, however, can grant limited stay and Rule 3A will not stand as a bar in view of the fact that Order 41 Rule 3A of the CPC cannot apply in any case of an order by virtue of Order 43 Rule 2, which enjoys application of the rules of Order 41 in the matters of procedure, and that also so far as may be. So, this is the order which was challenged before the Honorable Court. It is against an interlocutory order. The decree was not passed.
So according to you, there is a distinction if it is an appeal from an interlocutory order, then during the pendency of Section 5, it can be done. Or if it is appeal is against a decree, it cannot be done.
Yes.
Because, or in other way, this is a proposition that in case of an appeal against an order, this can be done.
I'm grateful, madam. Now, my lord, the another judgment which Mr. Ghosh has cited before your lordship, the division bench judgment of the Bombay High Court. And it is reported in the cost title is Bhagwan Ganpatrao Godse.
Yes,
is there.
Now, my lord, kindly come to paragraph 2 of the judgment.
Yes.
Now, my lord, the first paragraph, last two lines, the eviction suit was allowed by order dated 7th November 1985, and the respondent was ordered to vacate the premises within 30 days from the date of the order. The defendant preferred an appeal to the district judge at bid under Section 25 of the Hyderabad Rent Control Act. Kindly mark it, my lord, under Section 25 of the Hyderabad Rent Control Act, because it is a special provision. He urged that the notice of the proceedings before the Rent Controller was never served on him, and the order for substituted service was erroneously made. He came to know the order of eviction made ex parte on 14 December 1985, when he was served with the order of the Rent Controller through the Tahsildar bid. He preferred an appeal on 16 December 1985, which was within 30 days from the date of knowledge of the order of eviction. Thus, the appeal was not barred by law of limitation. With the appeal, the petitioner made a separate application for condonation of delay and stay of execution of the order. The applications were made out of abundant caution. The learned district judge heard counsels. The respondent urged that having regard to Order 41, Rule 3A of the Civil Code of Civil Procedure, the appellate court cannot grant interim stay until the application for condonation of delay was disposed of and the appeal was admitted. The district judge invoked the inherent powers of the civil courts and stayed execution of the order of eviction pending decision of the application for condonation of delay in filing the appeal. Here, my lord, the district was the person designator, not as a district judge. I shall show to your lordship that also.
There.
Now, my lord, kindly come to next page. The question for considerations. The civil division applications were heard by Ratnaparki J on February 28, 1986, but were not disposed of by him. After expressing his dissent from the view held by S.J. Deshpande J in Civil Division number such and such, he referred them to a larger bench. S.J. Deshpande J, while disposing of Civil Division and application number such and such, held that the provisions of Rule 3A, Sub-Rule 3 of Order 41, which prohibit the grant of stay, are directory and not mandatory. Now, my lord, skipping over that, that is the reference which was made. Now, my lord, kindly come to the paragraph 5. Upon hearing counsels for the petitioners and respondents, and upon reference made to us, we propose to frame the questions that arise for consideration. While referring the case to a revision bench, Ratnaparki J did not formulate the question that he referred to the revision bench. The arguments of counsel raised other incidental questions. We therefore address ourselves to the following questions. Having regard to the prohibition enacted by Rule 3A, Sub-Rule 3 of Order 41 of the Code of Civil Procedure, which directs that the court shall not make order of stay of the execution, is the appellate court empowered to make interim orders of stay of execution of the decrees appealed from pending disposal of the application for condonation of delay made under Order 41, Rule 3A, Sub-Rule 1. 2. In the appeals preferred under Section 25 of the Hyderabad Rent Control Act, is the district judge empowered to make an interim order of stay, notwithstanding the Order 41, Rule 3A of the Code of Civil Procedure.
Yes.
The question at 1 above raises certain further questions. Whether the prohibition enacted by the words shall not make order of stay of execution in Rule 3A, Sub-Rule 3 is mandatory. B. Whether the legislature intended that during the interim period between the making of the application for condonation of delay and the hearing under Order 41, Rule 3A, the decrees appealed from should be executed, thereby rendering the appeal infructuous. C. Whether the court can resort to its inherent power to prevent the failure of justice by granting interim stay, notwithstanding the aforementioned prohibition. The question at 2 above raises a further questions whether the Hyderabad Rent Control Rent Act, which is a special enactment governing special cases between landlord and tenant, should not prevail over the general law procedure laid down in the Civil Procedure Code. We are called upon to construe the provisions of Order 41, Rule 3A, which apparently takes away the power of the appellate court to grant interim stay before the disposal of the application for condonation of delay and the hearing of the appeal under under Rule 11 of Order 41 of the Code of Civil Procedure. Let us therefore have a look at the enactment. The Order 41 has the caption Appeals from Original Decrees. Section 96 of the Code of Civil Procedure creates a right of appeal from every decree passed by any court of original jurisdiction. Section 104 of the Code creates a right of appeal against the orders specified therein and those specified in Order 43 of the Code. Scheme of Order 41, Rule 3A is this: where an appellant presents an appeal which is barred by law of limitation, it shall be accompanied by an application for condonation of delay, supported by an affidavit setting forth facts with a view to satisfying the court that he had sufficient cause for not preferring the appeal within time. The court is then called upon to consider the merits of this application without issuing notice to the respondent. If the court finds that the grounds are untenable, no notice need be issued to the respondent on such application. If the court thinks fit, it may issue notice to the respondent. The respondent then appears. After hearing both parties, the court is required to dispose of the application for condonation of delay, but it shall do so before it proceeds to deal with the appeal under Rule 11 or Rule 13 as the case may be. Rule 11 empowers the court to examine the merits of the case in the appeal. It has two options. It may dismiss the appeal without notice to the respondent and to court from whose decree is appealed from. If it finds that appeal raises questions required to be heard after notice to the respondent, it may admit the appeal and issue notice to the respondent. But the last of the rule is that the court shall finally decide the application for condonation of delay before considering the merits of the appeal under Rule 11. In other words, it shall not postpone the consideration of the question of limitation beyond the date which is decides to hear the appeal under Rule 11. That is 60 days. Then the
Conclusion is at paragraph 27.
yes, paragraph
27.
and I want to cite some
Because what
paragraph.
you are saying that the district judge under that Hyderabad
Yes.
Control Act
Special
is a
enactment,
special act, so
so-
order 41 rule 3A will not apply. That's observation is paragraph 27.
Yes. That but my lord, it has been dealt with this in this judgment. Some paragraphs has been dealt with regard to order 41, scope of order 41 rule 3A, 3 and
So after that, the conclusions you will be getting in paragraph
No, my lord,
29.
paragraph 24 onwards. My lord, kindly come to my lord.
Yes.
Paragraph 24.
Yes.
Section 25 of the Hyderabad Rent Tax stay by the Appellate Court. That's the head note.
Yes.
Now, my lord, the question whether paragraph 24, the question whether district judge who exercise appellate powers under section 25 of the Hyderabad House Rent Eviction and Lease Control Act 1954 can stay execution of the order appealed from will have to be decided with reference to the provisions of that act.
Yes, not the order 41 rule 3.
Yes. The controller who exercised the original jurisdiction in respected of all matters to which the act extends in appointed by the government, determination of fair rent, eviction of tenants and all other actions provided by the act are instituted before the controller. Since the proceedings are not in the nature of suits, the Civil Procedure Code does not automatically apply. In the matter of summoning witness and compelling production of documents, section 23 enjoins the controller to follow the procedure laid down in the Code of Civil Procedure. But this power is qualified by the words so far as may be, thereby indicating that the whole procedure with its technicalities need not to be applied. Similarly, section 24 of the Act prescribes the procedure for inquiries under the Act. The rent controller shall follow as nearly as may be the procedure laid down in the Code of Civil Procedure. The appeals are provided by section 25 of the Act. Section 25(1) opens with the words, notwithstanding anything contained in any law for the time being in force, and goes on to lay down that an appeal from an order made by the controller shall lie to the district judge. In other words, the appeal does not lie to the district court, but to the district judge who has been designated as the appellate authority. The district judge who is the appellate authority is constituted as an adjudicating body exercising the appellate jurisdiction over the orders made by the controller. The appellate authority vested in the district judge is created by the Act for fulfilling the purpose of the Act. Subsection 4 of section 25 of the Act makes the order of the appellate authority final. It is not liable to be questioned in any court of law, whether in a suit or in other proceedings or by way of appeal. The nature of the jurisdiction exercised by the rent controller and the district judge under the Act is a special kind created to meet the special purpose of the Act. The designation of the district judge means particular individual holding of the office of district judge at any given point of time. The scheme of the Act, the nature of the jurisdiction, and the use the words district judge in section 25 and the finality attaching to his orders clearly signifies that appellate authority under section 25 is a tribunal and not a civil court. The Hyderabad Houses Rent Eviction and Lease Control Act 1954 is a special law. What is general law and what is special law is not always easy to decide, but the subject matter of the statute is an index to the understanding of the nature of the enactment. The preamble of the Act makes it clear that it is intended to provide for better control of rent of houses and to prevent unreasonable eviction of tenants therefrom, and the regulation of the leasing of the house in certain cases. It is intended to serve a specialized purpose. In its scope and ambit, it is narrow and restricted to the particular cases between landlord and tenant as compared to the general law governing properties. This restricted scope of the Act and the special purpose which it intended to serve make it a special law. On the other hand, the Code of Civil Procedure has a general application and is a general law. Order 41 Rule 3A, which precludes an appellate court from granting stay in circumstances stated therein is a part of the general law of Civil Procedure Code. Section 25 of the Hyderabad Rent, which provides the right of appeal, is part of the special enactment intended to serve the special cases arising under the Act. It is a basic rule of interpretation that general legislation must give way to the special legislation. The Hyderabad Rent Act and the appellate powers conferred by it do not preclude the district judge from granting stay pending consideration of the applications for condonation of delay. Since the special legislation does not create the prohibition similar to that the one contained in Order 41 Rule 3 of the Code of Civil Procedure, such prohibition has no application to the cases under the Hyderabad Rent Act. So, my lord, it was under the stay was granted under a special legislation act where, my lord, this Order 41 Rule 3A has no application. Under such circumstances, he is the finally adjudicating authority. He has granted stay, but there was no decree. So, my lord, Mr. Ghosh is submitting before your lordship that it's a general law. Order 41 Rule 3A will apply, and this decision will be applicable in our cause. To my submission, my lord, subject to your lordship's kind correction, that is not the exact, my lord, submission should be on behalf of Mr. Ghosh. So, my lord, this decision has no application. Relying on the self-same point which has been adjudicated by the Honorable Division Bench of the Bombay High Court, a single bench decision of the Bombay High Court is with me, my lord. Judgment.
Mr. Rai, do you have 86 Maharashtra Law Journal?
I don't have. I don't have, my lord. 80
point of time we had access to those Maharashtra Law Journal.
Well, I don't have, my lord. Maharashtra Journal, Law Journal may be available to one of the retired judges. But, my lord, I can't, presently I can't approach him for that. I also do not know, my lord, whether these books are also not available on.
From this gadget, that decision, in that decision, please kindly come to paragraph 32.
Yes.
Of
paragraph
that
32 on
judgment.
this judgment.
Mr.
Yes.
There's a reference of a Maharashtra Law Journal. You can find it out from your gadget. Sheikh Ibrahim versus Tekchand, 1986, Maharashtra Law Journal, 903. Because here, Mr. Rai, you are right that there, under the Hyderabad Rent Control Act, the district judge in the capacity of an authority.
Finally adjudicating authority.
Yes, has passed an order. And it has been held that Order 41 Rule 3A will not apply, or notwithstanding that he has power.
Yes.
He has exercised that power. But after recording that, the division bench has considered the effect of Order 41 Rule 3A.
But, my lord, it says the division bench is of the view that it's a special legislation. It has been
there.
Clearly mentioned there that should prevail over the general law.
From paragraph 28, you'll be finding some discussions on Order 41 Rule 3A.
Yes.
So there, the division bench considered what is the effect. There, it took into consideration the.
That's why, my lord, this conclusion part also based upon some other observations which has been made earlier in this application. Because, my lord, the breathing time, the learned judge, while deciding that, my lord, took the breathing time of the appellant. What should be the breathing time of the appellant? That is the 60 days. So far as Order 41 Rule 11, that is not that has been mentioned here.
Another interesting thing is, if you can
paragraph 32.
না দেখে তো পড়া যাবে না 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 দেখে তো পড়া যাবে না না
kindly come to paragraph 31 of that judgment.
Yes.
It's the concurring judgment by the other honorable judge. On order 41 rule 3A.
Yes.
It says last part of paragraph, however, law is meant to do substantial justice and we should not stick to the technicalities, niceties. If there is a prima facie good reason for condonation of delay and stay is not granted, then we fear that what for the purpose of the appeal would be frustrated and what is demanded in the appeal is deemed to have been denied to the party even before the admission of the appeal, and the other party may take possession in haste and hurry if stay is not granted. Then next paragraph, last, relying on that, further there is a direct decision in 1986 Maharashtra Law Journal. The learned judge took the view that the appellate court can grant interim relief till the decision of
The application for
application
condonation of
for condonation of delay, because the matter is pending.
But Malad, the basic difference, as I have trying to impress your lordship, that this is a regular appeal from decree, and that was an by special statute an appeal was prepared. The learned district judge as a personal designator, being the appellate forum, has to decide that thing, and that decision should be a final decision, no further challenge of that decision in any forum. So that is the basic difference upon which this
the other decision we are trying to submit.
Another
single bench judgment of that court or
yes. That is reported in 2019 1 Maharashtra Law Journal 656. I have not handed over as yet. Oh, I'm told that based on this judgment, there is also a 9 years delay in preparing the appeal. The learned judge basically discussed about what it has been found in this judgment of 1987, that is Ganpati Rao Godse's judgment, and ultimately held that the stay should not be granted.
In view of order 41 rule 3A.
Rule 3A.
Please show me that. Where is that?
Okay, copy down it. Okay.
Paragraph 16.
Yes.
Or I'm sorry, kindly come to paragraph 14. Paragraph 14, it's next page. Paragraph 14 starts
yes.
Next page, line about 3, 4, 5, 6, 7, 8 to 9 lines from the bottom. The line starts with the legislature intent.
Yes.
The legislature intent that the right of appeal created by section 96 should be advanced. The intent was that the court should not admit appeal and stay execution of the decrees without deciding the question of limitation. The provision of period of 60 days is an indication of the legislative awareness that during these 60 days, the right of appeal should not be frustrated. We are of the opinion that the legislature intend that the appellate court may exercise its power granting stay during these 60 days, but shall not extend it beyond 60 days without admitting the appeal. So, the provisions that is there, that the appeal under order 41 rule 11 has to be heard within 60 days, that is the breathing time. The court may grant stay with regard to the execution procedure.
So according to you, if at all, it should be 60 days to
Not
enable
beyond
the
that.
hearing of the appeal.
Not beyond that. That's my humble submission before your lordships. Now, no, that fact is already there. The fact is this about my title. Up to this honorable court, my title has been perfected.
Evidence.
And about this suit, the suit defeat ex parte, order 9 rule 13 dismissed, restoration of an order 9 rule 13 that has gone section 47 up to section 47. The scope, the satisfaction of the decree is one of the ingredients in section 47. That has been decided up to the honorable apex court. So, virtually there is no scope of reopening the trial court's judgment of granting decree. That's my submission.
Yes,
Lord, so far, Lord, this 60 days is concerned, Lord. Your Lordship, I have pointed out last occasion that when the application of Section 5 of the Limitation Act in connection with the appeal was taken up by the learned court below, Lord, they opposed that it cannot be disposed of on affidavit, but they should be allowed to examine, cross-examine the petitioner. That is one aspect of it. That's why, Lord, the matter has been fixed for hearing, and our evidence has been closed, and now they are to do evidence. Second question is, Lord, so far the stay, power to grant stay during pendency of the application for condonation of delay is concerned, Lord has pointed out that the contention of the learned advocate appearing on behalf of the other side in the Justice Honorable Justice Kulpal and PC Bodo, in that case, it was taken the appeal is not there. It has not borne. Therefore, there is no question during pendency. Lord, that has been not overruled, and Lord, relying upon the judgment of Honorable Justice Nag, their lordships granted stay here. But distinction is that the principle is same. That whether its stay can be granted during pendency of the appeal, whether interlocutory order or final order, whatever it may be. Lord, because the delay application for condonation of delay is filed and explained the what is the reason for delay, and the court finds that there is sufficient reason, court will condone the delay, and then the appeal will be hard on merit. But here also the appeal has been preferred, pointing out certain grounds which are not that they have admitted that is a irrevocable licensing and made permanent construction. They have admitted in the evidence. But therefore, appeal has also some merit. That's why, Lord, if it is at the threshold, whether Section 5 has merit or not merit, without deciding the same, it cannot be, this should not be allowed to take possession. But at the threshold, the application was filed, the court held that it is the initial stage, not at this stage. But when the police help has been granted and the date is fixed for taking possession, we made another application. That has been rejected, that this cannot be done. This is the ground. And Lord, that apart, your Lordship rightly pointed out that Pannalal Jaiswal's case. There also, your Lordship is a decision in case Section 5 is rejected or is dismissed, particular appeal lies.
You have Pannalal.
Yes, I have brought it, Lord.
Section 5, there the finally it was decided in Section 5. Section 5 was against that order, not against decree.
Lord, kindly, this is elaborately, and Lord, the judgment of the Bombay High Court also, Lord, last.
You have a Pannalal Jaiswal?
Yes.
No, sir. Photocopy do you have?
Lord, I'll give you. Your Lordship, kindly see. And Lord, kindly see there also that it is a practically merit. Dismissal of the Section 5. Calcutta High
I'm
Court,
handing
Lord.
what you, Lordship.
Mr. Pannalal.
Photocopy.
The full bench decision of the Calcutta High Court has also been, Lord, overruled there.
Yes, 76 Calcutta 415
Yes.
was overruled.
Oh, yes.
Because that judgment, it says that unless Section 5 is allowed,
yes,
there is no appeal in the eye of
appeal
law.
in the eye of law.
And here it says it's a decision in the appeal.
Isn't
That's
it?
the distinction.
Yes.
So if it is a decision in the appeal, then can you say that there was no appeal in the eye of law during the pendency of the Section 5?
Lord,
that's the only.
Lord, Mr. Arun Prakash Chatterjee, Lord, raised that question and argued that before Justice Asam Kulpal and PC Bodo. There is no existence of appeal until
Yes, but now that view has been. Yes. Thus, the position that emerges on a survey of the authorities is that an appeal filed along with an application for condoning the delay in filing that appeal, when dismissed on refusal to condone the delay, is nevertheless a decision in the appeal.
Yes.
What is the meaning of this? If there is no existence of an appeal, can it be a decision in the appeal?
The fact is this: the decree has not been reached up to the Supreme Court.
Mr. Rai, only one thing.
There
Question is, This is, I think, Order 9 Rule 13.
Yes.
Order 9
Rule 13.
Order 9 Rule 13 with Section 5.
Yes.
Now, Section 5, unless it is allowed, there is no Order 9 Rule 13 in the eye of law. Or if you title appeal along with the Section 5, unless Section 5 is allowed, there is no appeal in the eye of law. So, rejection of Section 5 cannot be a decision in the appeal. It's a decision in the application then. So, when you say rejection of Section 5 is a decision in the appeal, so there has to be an existence of an appeal. Can you say there is no appeal?
That is a proposed appeal. Appeal and the proposed appeal, so long it is not heard under Order 41 Rule 11.
Right.
It has not been clarified there that it's a regular appeal.
That was the view of the 1976 Calcutta, because there is no existence. That is why, because now, previously what we used to do is 76 Calcutta, it's revision. Why? Because it's not a decision in the appeal. It's a decision on the application. So if it is a decision on the application, not in the appeal, so it's an interlocutory order, you have to challenge in revision. Now here that has been stopped. That judgment has been overruled. So now it's not a decision in the application, it's a decision in the appeal. So once you say it's a decision in the appeal, can you say unless and until it is allowed, its appeal is non-est?
In existence, yes. That's why the problem lies. That's why these.
Now, if appeal is in the eye of law, then whether
the facts is totally different. They are in.
I'm not on the facts. I'm only on
after the
effect of that Section 5?
After it's reached its final judgment in the apex court, whatever my learned friend is now submitting is he wants to reopening everything. That he can't.
What final judgment?
Because it has reached up to the according to me, the decision has been reached up to the Honorable Apex Court.
Is Order 9 Rule 13.
No.
That is order.
Merit.
Nothing.
Appeal, the merit of the suit. Because he has filed Section 47 challenging what? Challenging the judgment, the scope of the judgment that has reached its finality.
Only one thing, Mr. Rai. Initially, there was an ex parte decree in your case.
Yes.
So thereafter, Order 9 Rule 13.
Dismissed.
Yes. Order 9 Rule 13 dismissed. Then up to the Supreme Court.
No.
47 up to the Supreme Court.
Yes.
So 47 is challenging the ex parte decree.
Yes.
Or saying that execution from the ex parte decree. Now only one thing, ex parte decree, Order 9 Rule 13 dismissal does not take away the right to challenge the decree by way of a regular appeal. That can be done. So whether the Section 5 will be allowed or not, that's a different thing altogether. Explanation to Order 9 Rule 13 makes it clear. So even if Order 9 Rule 13, you can simultaneously...
Order 9 Rule 13 has not been proceeded with. Order 9 Rule 13 dismissed, restoration has no order. So, that chapter is also closed.
No, that chapter closed.
Scope of suit closed. Order 9 Rule 13 scope.
Can you say...
Scope closed. Section 47 closed. So what remains, I am asking myself.
No, only one thing. Order 9 Rule 13, even if it is dismissed, can you say the regular title appeal is barred?
No, I am not
So
saying that. I am not saying that.
I'm on
But
that.
what I am submitting before a lordship, these what is remain in this appeal itself, that has been filed after 10 years. What it remains, because whatever the decision that has been arrived in the decree passed by the learned trial judge, that has reached its finality up to the apex court. That's my submission. In that light, the present appeal and the Section 5 has to be considered. According to me, subject to your lordship's kind correction.
So according to you, after this 47 rejection up to the Supreme Court,
and your lordship kindly excuse me, and the very recent judgment that the execution has to be disposed of within 6 months.
Sir, Rai, that's one way of looking at it.
We are, this is languishing for the last for 14 years.
Yes, only one thing. So since according to you, from 47, it has reached to the Honorable Supreme Court. It has reached, attained finality. So according to you, that decree which has been tested, according to you,
has been tested up to the
tested by the Honorable Supreme Court, cannot be now reopened
by filing of an appeal.
Yes, by filing of an appeal. So according to you, in other way, appeal is not maintainable.
Yes. Yes,
That's your
I'm grateful, madam. That should be my contention.
Your section 47 application was allowed on contest by the learned trial.
Thereafter, it
Yes.
has been set aside.
It has not set aside by
So,
this court, and SLP was dismissed, not on merit.
So the effect is
Yes.
that section 47
Yes,
has been
yes.
dismissed.
But
Anything
that-
more, Mr. Ghosh?
No. But that's why my submission is not that will not prevent the proceeding with the appeal, regular appeal. Yes. Order 13,
What is the date in the execution?
14th July. This is the order.
Give me some time, Mr. Rai. I'm praying for time and accommodation.
The case was not challenged in 47.
That one.
Heard the learned advocates. Yes, call the next matter.
I'm grateful.
My lord, I appear for the petitioner. Well, this is an application for expeditious disposal, my lord, of a partition suit, which is pending since 1996. My lord, issues were framed on 22nd of April 2010. But thereafter, in 2014, my client, who is a defendant number 2B, he filed an application for appointment of a receiver in respect of the property, so that out of the rent, my lord, the maintenance of the property can be done. But that has been kept pending, say, till now. Now, my lord, we filed an application in 2024. Kindly comes to page 31. This application was disposed of by the coordinate bench with the direction, my lord, upon the trial court to make sincere endeavor to dispose of the suit along
Order
with
dated?
page 31. Order dated 2nd of May 24. Right, 24, yes. I came up before this court.
Yes.
Kindly sees the last paragraph. Under the
Yes.
circumstances, revisional application is disposed of with the direction upon the trial court.
Now, what is the stage of the suit?
My lord, nothing, my lord. Thereafter, my lord, this was communicated to the court below on 22nd of May 24. I have annexed the entire order sheet.
Receiver application has been
Still pending, still pending. Now, my lord, that 1 year is also
objection has
gone.
been filed.
My lord?
Written objection has been filed.
Yes, objection has been filed to that, but that is still pending till date. Now, my lord, the plaintiff, in the meantime, came up with another application. My lord, that lordship, your order will find at page 33. But there, my lord, the plaintiff did not state anything about the receiver's application or any interlocutory applications. He came up with a simple prayer for disposal of the suit. There also, my lord, the plaintiff got an order of 1 year.
This application under Article 220.
একটু ফাইলটা দেবেন আমার।
So the position has changed. Now we
position has changed. Yes, Mr.
in the same
Bhattacharya.
one. Now he is the opposite party. I am the petitioner. My lord, just to refresh your lordship's memory.
What is the order under challenge?
Order, my lord, a status quo ante was passed when there was no status quo. Yes, my lord, just to refresh your lordship's memory, my lord. Here, my lord, an eviction order was passed, and thereafter an appeal was preferred. Now, my lord, in the appeal, there was an order of stay. Now, my lord, the order of stay ultimately was there for 5 months.
So, Bhattacharya, is it that matter?
Yes, that matter.
226, 227.
226, 227.
After your lordship's intervention to the extent permitting me to withdraw and agitate the point, we have taken out an application in which he has used a written objection, and on a contested hearing, my lord, the position has been reversed by holding, my lord, that the action of the authorities on the penultimate day, 17th was the date fixed, 16th by my lord putting a padlock is absolutely an arbitrary decision, and my lord, it is in breach of my lord Wednesbury reasonableness. That is what the court has held, and it has restored the status quo, though my lord, the order till date has not been complied with, for which my lord, a separate step might be taken. Hearing of the principal appeal, my lord, was fixed today, and it has been concluded from our end. 3 dates have been fixed by the learned court below. 2 dates, my lord, in the misappeal 160 of 2022, filed by my learned friend's client, or filed by us, my lord, against the order, whereby, my lord, 2 dates have been fixed, my lord, on the 29th and 1st of August.
Oh, there are 2 appeals, my lord. Now, my lord, allow me to place it, my lord.
But let the appeal be disposed.
My lord, I tell your lordship, my lord, the order impugned is completely illegal. My lord, there are 3 propositions of law I am going to advance before your lordship. My lord, if there is no interim order, if the interim order was there, if there is no interim order and the position has altered, my lord, Supreme Court has said the interim order cannot be reimposed. Number 1. Number 2, to pass an order of status quo ante, there has to be an order of status quo. Number 3, my lord, here on his application, an order of status quo was passed when I was in position. Now, if I was in position without varying that order, my lord, whether, my lord, an order for removal of the padlock can be passed. My lord, I just take your lordship, my lord, just refresh your lordship memory, place the impugned order, and that's it, my lord. Now, my lord, here, initially, my lord, in the app.
How much time it will take?
My lord, 20-25 minutes. Tomorrow, my lord. Tomorrow, I can come back, your lordship. If
I am leaving.
If lordships give some precedence,
But let them, my lord, please open the padlock.
No. Then, my lord, what is left in my civil division left? Tomorrow.
Tomorrow
Tomorrow, my lord, in the morning.
will appear. It's in the list.
My lord, the difficulty is, my lord, your lordship knows, my lord, what prompted us to, my lord, trouble your lordship while sitting in courtroom number 19. And, my lord, the position, my lord, is unreversed.
Well, I will add another point, my lord. Looking at the conduct of the advocate of the other
Last
side.
motion item of today.
I know.
I have reached.
Yes.
Apart
Yes,
from
yes,
other
yes.
So let it appear tomorrow fairly at the top, my lord, in the motion.
44 motions were there.
That we know, my lord. Kindly do not embarrass me by saying all these things.
Tomorrow, hopefully it will be
My lord, these competent people, if they go that side, my lord, it will be, my lord, as good.
So, hopefully it will be reached. If not reached, mention by 4:15 tomorrow.
No. I will not mention, my lord, order today, my lord, for all benefit.
One line order
Of course.
will help both of you.
My lord, kindly fix it at 3 or 3:30, my lord. 3 or 3:30, my lord. Subject to my lord, my lordship's heavy list. 3 or heavy list.
Mr. Nah commences his argument but could not conclude. This is not taken up before 4, please remind me.
Lordship, grateful.
Let's call the next matter.
Grateful, much obliged.
Grateful.
Not today, আরেকটা
বাড়ি যায় আর কিছু পাসওয়ার্ড আছে কালারফুল আচ্ছা